The meeting of the Criminal Law Subcommittee will start at in about 45 minutes at 2:45 due to a conflict with appropriations. So sorry but we'll say a time certain, cross fingers, 2:45.
Okay.
The meeting of the Criminal Law Subcommittee of the House Courts Committee will come to order. Clerk, please open the roll. Members, indicate your attendance. Okay, we have a quorum. Because of the way in which this meeting's gotten delayed, I'm going to call bills in the order in this way. What's on the docket in that order of the people, of the patrons who are not on the committee. So the first one then is HB 240, Gardner, Delegate Gardner.
Good afternoon, Madam Chair and members of the committee. I have HB 240. This is a bill that we kind of went over briefly in a previous subcommittee and tried to do some amendments to work on the fix. We still have amendments, so do I need to move the amendment?
Move the amendments. Any discussion? All those in favor say aye. Aye. Opposed? They are before us.
Okay, Madam Chair, do you want me to just go over the bill again, totally? Happy to. Bill 240 is related to what the bill does is under existing Virginia law for admitting bail. It, prior to the bail hearing, that the judicial officer, the current code says, shall to the extent feasible attain a person's criminal history. Given the Virginia's court system, we thought that the information would be readily available. It is not. So the amendment actually says that the judicial officers shall attempt to obtain and review any emergency custody order, temporary custody order, or involuntary admission order. Basically, this bill, I brought this bill because on July 5th, Charlie Bowers' mother took him to the hospital and he was suffering a schizoaffective disorder incident. A mental health professional evaluated him and recommended he be placed under a temporary detention order. In the early hours of July 6th, a Richmond judge issued a TDO requiring Mr. Byers to receive mental health treatment in a psychiatric facility. Later that afternoon, Mr. Byers was admitted, and subsequently, he actually was accused of kicking a nurse, so he was removed from the hospital and taken to jail. This facility never communicated Mr. Byers' TDO status or the dire mental health needs to the police. When Mr. Byers appeared before the Richmond magistrate on the charges of assault, he was released on his own recognizance because the magistrate was unaware of the TDO. On July 8th, Mr. Byers was shot multiple times, including in the back, as he retreated and was killed by the Chesterfield police officer during his mental health crisis. While there are many tragic aspects of this death, closing the loophole would at least requiring them to attempt to get this information, we hope will prevent another family from having this happen. Thank you, Madam Chair.
Thank you very much for that presentation and history. Are there any questions or concerns? Seeing no one wishing to speak, is there anyone in the audience who would like to testify in favor of House Bill 240? Please come forward. If you could limit your remarks to 2 minutes.
This is my son, Charlie. And people who are in psychosis, like Charlie was, they desperately rely on people like us to help them when they can't help themselves. And it is within our power to make sure that they get back to the hospital where they need to be. And this bill is a good first step in that direction of helping those people get the help that they need. So I urge you to vote yes and send it to committee. Thank you so much for letting us speak.
Thank you. Is there anyone wishing to speak in opposition to House Bill 240? Seeing none, and there's no one online, Council, are there any questions or concerns to be raised? You have the final word.
Madam Chair. Madam Chair. Madam Chair.
I know it needs to be referred, but
Can I ask the patron a question?
Yes.
One of the things I struggle with this bill is good thing about coming with a bill is you present a problem and you're coming with a solution. What I'm concerned about is this is not the solution. And the reason why I say that, there's a lot of different things to this one scenario where the system failed. And I think going upstream where it shouldn't have happened is the individual should not have left the hospital, should have been there and stayed there and not relied on the magistrate or a court to make sure that we get this person assistance. And so I think the solution probably rests closer to keeping them, stabilizing them in the hospital before taking them out of that situation straight to the magistrate. And so that's where I think the solution lies for most folks. I don't know if we get your reaction to that. I know you had a meeting with, we heard this bill, I guess earlier, a couple of days ago, I guess, things run together, and trying to sort of have a meeting of the minds. Can you talk a little bit about how that conversation went and did you consider what I'm proposing is moving the solution further upstream?
Madam Chair.
Please.
Delegate Hope, you're right. There were a whole lot of things that went wrong in this situation. We did a lot of research over a year trying to find some possible solutions. This is not the end-all, be-all to fix this. This will not do that. That was not the intent. It was an attempt to make a first step in a process that we thought we could at least get through. We did. I talked to got the information briefly from the advocates, and then we worked with the Supreme Court. We actually came up with a solution that was agreeable, at least to myself and to the Supreme Court. The advocates, their concern was that it may cause additional time. Nobody could definitively say whether that would do that. There's a lot I also talked about how we can fix getting the information and the hospital, but it was just too big, so this was a first step.
Any further questions? I also see Delegate Davis.
Thank you, Madam Chair. I have a question for legal.
Please.
My question is, do the officers have access to get this information?
OES may have more information, but my understanding is they do not. It would only be if an officer had personal knowledge of previous interactions with the defendant or if they had been in the hospital with a person under a TDO. It's not something they have access to like a VSIN.
Follow-up question, Madam Chair?
Please.
Does this section also, if the officer did know about it, and did not divulge it, does that open them up to civil liability?
It does not say that. It just says if it's provided if the information is provided to the judicial officer. But it does say if they have knowledge of it, they're supposed to relay that information. Yes.
Shall.
Yeah.
So does that open, if an officer does not, does it open them up to civil liability?
Then you're asking me a question about qualified immunity and stuff like that, but it could potentially.
Thank you.
Thank you. And I would observe in that line of questioning that, again, the wording is to be taken as a whole. If you have knowledge, you shall. So that the two things go together. It shall does not stand on its own. While I am speaking to the bill and both comments that we have just heard, as well as the presentation of the patron, as you look at the code without any of the new language in basically mental health condition doesn't exist. And so it's assumed that you are going to bring that this information somehow exists and in the decision being made by the magistrate. So at least by what I'm going to call this update of the code, the fact that there may be something more than just the person's criminal history is now noted in the code, and the direction of the code is to at least be aware of it, at least try to ask it, at least bring it forward if you know it, and it doesn't happen to be in the person's criminal history. I'm very glad to have received a notice that if we are to report this, we are to refer it to appropriations, where I think more and more of what needs to be done in the system as a whole will come forward because of this this start, if you will, in making sure that we update our system so that it reflects not just criminal history, but also mental health issues. Delegate,
If I can make
Chairman Hope.
If I can make a comment to the subcommittee, sometimes we do this. We take the temperature of the subcommittee. I think if we do vote favorably for the policy, this will go to appropriations, and who knows what happens then. And so I'm not sure that this is the solution, because I think there's probably a lot of people that fall into this category. I don't think this individual should have left the hospital, and so to go to the magistrate, I think that the person under TDO should get stabilized and get the help that they need. I don't think that's the last place they need, is be taken to a magistrate or to a jail. I don't know what's going to happen to the bill, and I don't know what people are going to do here in the subcommittee, but I as a chair of the committee, I would pledge, I think this does warrant to be studied. I would, if the outcome is not what the patron would like, I would commit to writing a letter to Behavioral Health Commission, because I do think that this is something that should be evaluated to bring all the stakeholders together. I do think that this is not just a one-off. I do think it happens more frequently. And I think that there should be, come back with a policy that solves this problem. Thank you, Madam Chair.
Thank you. And again, this is unfortunate dialogue, but I am going to add that on behalf of Nakasha McKenna, who was lost about 6, 7 years ago through a number of steps that were not in, I do not see any harm in the language before us, and it's not in conflict with the study that I think your letter would be most welcome. But I don't see any harm in this step forward, knowing how many steps are involved where a person loses their life because of the complexity that has not been modernized in the way in which we handle cases. Seeing no one else wishing to speak, you have the final word as patron.
Madam Chair, committee members, as Delegate Hope said, this is a big problem. It's going to take a lot of work. However, there are some steps that we can take, and not only for me, this is an attempt. We also talk with the Office of the Supreme Court. They're actually going to add a checklist to their magistrate's additional box on the checklist. And the Richmond Police, as well as the hospital, as a result of this, have started looking at their policies as well, because they know they made some failures.
Thank you. We operate on motion.
Madam Chair,
Delegate Williams.
I would move to politely lay this on the table and ask the Uber chair if he would follow up with a letter, because I think this is a good thing that we don't need to drop.
It has been moved and seconded that the bill before us be tabled with the Uber chair writing a letter to, I believe, the Behavioral Health Commission. Was that correct? Mr. Uber Chair, Behavioral Health Commission?
Madam Chair, I have a substitute
yes,
motion.
Delegate Cousins.
Thank you. Just considering the sensitive nature of the work that needs to be done, rather than table this bill, I would move to continue it to 2027 with a letter to the
There
Behavioral
has been
Health
a motion
Commission.
then to continue the bill to 2027. Is there a second?
Madam Chair, I withdraw my motion and join her motion. I think that's a good idea.
Okay, then the motion before us is to carry over this bill to 2027. Delegate, Mr. Uber Chair, I guess it's Mr. Uber Chair, this doesn't preclude you writing a letter to the,
No,
thank you.
and the patron and I can get together and work on the language, but we can send that to the Behavioral Health Commission, because I do think that this does warrant a study. I'm glad that you brought this forward to us. Like I said, I think that this happens much more frequently than people realized, and I think it does involve a comprehensive look.
So that I will formalize then, the motion before us is to carry over the substitute with a letter to the Behavioral Health Commission. Clerk, open the roll. Members cast your vote. Oh, it's a voice vote. I have been reminded it's a voice vote. Thank you. All those in favor say aye. Aye. Opposed? Thank you very much, Delegate.
Thank you, Madam Chair, members of the committee.
Before we go on to the next bills on the docket, I wanted to report that, actually, it would be the next bill, HB 1105. Delegate Kilgore asked that this bill be stricken.
So moved. Second.
It's been moved and seconded that the bill be stricken at the request of the patron. All those in favor say aye. I believe that's no, it's a recorded vote. Clerk, any debate? Please open the roll. Members, cast your vote. HB 1105 has been stricken by a vote of 10-0 at the request of the patron. And while I am doing administrative, I would also report that HB 1215, Delegate Oates requested that it be laid on the table. This is a voice vote. All those in favor say aye. Aye. Opposed? Now we return then to the docket before us, and the next person who is in the room is not Delegate Shin. The next person would be LaVere Bowling. You're on. Delegate. No, it's a voice vote.
To lay on the.
My apologies. Before we begin, we needed to take a recorded vote on the motion to table HB 1215. Please open the roll. Members, cast your vote. It is tabled by a vote of 11-0, 10-0. All those, thank you very much. Now, Delegate LaVere Bowling.
All right. Good afternoon, Madam Chair, members of the subcommittee. Before you do have HB 438, and I do in fact have a substitute.
Is there a motion?
Second.
Any discussion? All those in favor say aye. Opposed? Substitutes before us.
Thank you, Madam Chair, members. HB 438, this bill expands appropriate access to diversion for youth by updating the current code that limits which cases may be diverted before a petition is filed in juvenile court, and by creating a clear pathway for cases to be redirected to diversion even after a petition has been filed. Under current law, certain petitions are excluded from pre-filing diversion at the court service unit level. The substitute narrows those exclusions and gives the system more flexibility to use diversion when it is appropriate and in the best interest of the child and the community. In addition, the bill provides that after a petition is filed, the juvenile's attorney, or the Commonwealth's attorney may move the court to send the matter back to the court service unit for diversion. If the court grants that motion, the petition is dismissed and the record is expunged following successful diversion. This approach recognizes what we know from data and practice, that appropriate diversion reduces recidivism, it improves youth outcomes, and avoids saddling young people with court records when accountability and services can be delivered much more effectively outside formal adjudication. The substitute keeps judicial discretion in place, it preserves prosecutorial input, and ensures diversion remains structured and supervised, not automatic. Madam Chair, this is, in my opinion, a balanced reform that increases flexibility, supports better youth outcomes, and uses court resources much more wisely. And with that, I will stop and respectfully ask for your support on the bill with substitute.
Thank you. Are there any questions or comments from the seeing no one? Excuse me, Delegate Davis.
Thank you, Madam Chair. A question for council. What are the new crimes that allows diversion?
Right, so previously you couldn't do diversion if you had a violent felony. If it was a violent felony, it could be your first one. You had not previously been proceeded against informally or adjudicated delinquent for an offense that would be a felony if committed by an adult. That is still the case. The only thing that's been struck out is court service unit could defer someone pre-petition. The amendment would allow it if they've been proceeded against informally before. So if they had a petty larceny proceeded against informally, they get another petty larceny, that wouldn't automatically have to a petition be brought. CSU could make that determination. The new amendment with regard to the new procedure is now if any petition is filed in the juvenile court, could be any crime, the court on motion of the attorney for the Commonwealth or the defense attorney could defer that out to CSU and proceed informally. It doesn't mean they have to, doesn't mean they shall. It just means that there's no bar to it if the court grants the motion to defer.
Follow-up question.
Delegate Davis?
So are you telling me on any violent crime that can be done on?
If the court grants the motion, it could be referred out for diversion. Now, if they don't successfully complete diversion, a petition could immediately be filed on the violent felony.
Follow-up.
Thank you, Delegate Davis.
So murder could be diverted, use diversion.
I mean, technically, if they're not being tried as an adult, but I highly doubt a court would grant that motion on a murder case. And I doubt CSU would take a murder case. But technically, based on the language of the statute, if someone made a motion and the court granted that, that could be deferred.
Thank you.
Is there not before I recognize Delegate Williams, is there not a requirement that if there were a murder case that the juvenile would be considered to be tried as an adult?
Mm-hmm. I'm sorry, could you repeat?
I thought there was a specific provision that if you have a murder charge, that is one of those mandatory being tried as adult at a certain age.
It depends on the age of the juvenile.
Can not to say age, yes, but an age. Thank you. Delegate Williams.
Yes, question for council. I always get confused about where the age range is for juvenile, because I don't think it stops at 18. Is this one that stops at 18? Sometimes they go into 19,
Yes.
20, 21.
Yes. A juvenile stops being a juvenile at 18. There are some things in the code where a juvenile could be held in juvenile detention, a sentence until they're 21. Mm-hmm. But if a crime is committed after they turn 18, they are treated as an adult by law.
That's my question.
Yeah.
Seeing no one else wishing to speak, are there any other concerns before we open to testimony? Is there anyone in the room wishing to speak for HB 438? Please come forward.
Good morning, Madam Chair, members of the committee.
Remarks in 2 minutes. Thank you.
Okay. We thank the delegate for bringing this bill. And putting it simply, diversion works. Virginia's own Department of Juvenile Justice 2025 Data Resource Guide, it makes this clear. In fiscal year 2024, the 12-month rearrest rate for youth in diversion was 11.3%, compared to the 30% for probation and close to 50% for youth who were in release from direct care. These trends, they've been consistent from 2019 to 2024. This data shows that diversion is not just an alternative, it's the most effective option to prevent future involvement with the system. Even though youth who are diverted away from court experience significantly better outcomes than those who are placed on probation or direct care, under current policy, young people who make a second mistake, they are denied that meaningful access to be proven, that's proven to be more effective. So, importantly, please note that diversion programs, they are significantly less expensive, and they still hold youth accountable by providing structure, support, and opportunity for growth. It limits limiting youth to a single diversion opportunity, it contradicts the evidence, it ignores fiscal responsibility, and it increases the likelihood that youth will be pushed into more punitive pathways. We urge the committee to take this data-driven, youth-centered approach by removing the cap on diversion eligibility and allowing greater access so our young people will have the opportunity to be successful. Please support this bill. And I'm speaking on behalf of Rise for Youth and the Virginia State Conference NAACP.
Thank you. The next speaker.
Good afternoon, Madam Chair and members of the committee. I'm Ashley Shapiro from Justice Forward Virginia, and we do support this bill. This bill does expand opportunities for diversion, but doesn't require it in any way. It supports the overwhelming research, as Ms. Slater just said, about research that over-supervising children and over-exposing children to the criminal legal system actually increases criminality and increases recidivism. This bill recognizes that and gives children second chances and gives them a chance at diversion. I have been public defender for 14 years. I've seen children in diversion. That does not mean a get-out-of-jail-free card. They still have to have supervision, sometimes community service. They can get services through the court system. They can sometimes be connected with the Department of Social Services to also get services for the youth and their family. So this still provides valuable resources to the child to make sure. That's why the recidivism rate does go down when they have this type of opportunity, and allows children to have a community-based outcome instead of a court-based outcome. So we do support this bill and ask that you all support it as well.
Thank you. Is there anyone in the room wishing to speak against HB 438? 2 minutes, please.
Good afternoon, everyone. Chairwoman, my name is Bethany Harrison. I'm the Commonwealth Attorney for the City of Lynchburg, here on behalf of the Virginia Association of Commonwealth Attorneys, with an oppose, because what we would ask is, like the parallel Senate bill, the language used is with consent of the Commonwealth. And so even if you still include violent felonies in there, you would still have the ability for the Commonwealth to have some discretion there about what goes to diversion in this instance. And even when you have a case go through regular adjudication, you still have those programs and diversion, ability to take things under advisement, those sort of resources available to you. So that's our main concern, I guess. Thank you.
Thank you. If I may ask a question, please. Does VACA support the Senate bill with the agreement of the Commonwealth's attorney on the motion?
Yes, and I think prosecutors have helped work on the language for the Senate Bill 70 that is the parallel to this.
Thank you. Now I will turn to those who have signed up online, and we have Ms. Chelsea Delgado from the Legal Aid Justice Center. Please proceed.
Good afternoon. Thank you. Good afternoon. Chelsea Delgado on behalf of the Legal Aid Justice Center. LAJC supports HB 438. Diversion programs such as restorative justice hold a youth accountable without the cost of formal court processing. We urge you to support the bill. Thank you very much.
Thank you. Seeing no one else indicating they'd like to speak, let me ask counsel before I ask for the final word from the patron. Anything that you'd like to bring forward?
Not besides what's already been said.
Okay. Patron?
No final words, Madam Chair. Well, actually, yes, let me use some final words. It's Friday. We want to get out of here.
Words. It's okay.
Words. So many words. I just want to thank the advocates who came to me with this piece of legislation and the idea. I know in my own county, we do in fact offer diversion programming, and I've seen firsthand for many of my constituents themselves and others across the Commonwealth what a difference it can make. And so expanding these opportunities, I think, are really important for those who go through the program, but also for our court systems who are overloaded, their dockets are full, and they need some assistance. And also, they know that ruling and creating a record for a juvenile in particular is not always the best case. Sometimes everyone just needs a little helping hand, and diversion programming can do that with the support that it offers. So I thank you for your consideration today.
Thank you. Okay. Delegate Davis.
I would question for the patron, would you consider that a friendly amendment with being consistent with the Senate bill?
I believe my advocates don't love it. We were hoping to go to conference. We were hoping to work it out in conference, I would say to the delegate, Madam Chair. But, I'm at the discretion of this committee, so.
If I may respond, we're only halfway through, so this way at least we have the two versions going and an opportunity still to make that resolution.
Madam Chair.
Delegate Williams.
I think Davis just volunteered for conference committee.
Oh, well, thank you. I will note that.
Second.
Okay, it has been moved and seconded that report HB 438 with substitute. Clerk, please are there any comments? Open the roll, cast your vote. Okay, HB 438 reports with substitute by a vote of 8-1.
Thank you.
Thank you, Delegate LaVere Foley. Now, I think the next one on the list is, who is not a member, is HB 648. Delegate Kent.
Thank you, Madam Chair.
Please proceed.
Thank you, Madam Chair. I have an amendment in the nature of substitute to HB 648. Hopefully there are paper copies as well as online copies.
Move the amendment.
Moved and seconded the line amendments or as a substitute. Any discussion? All those in favor say aye.
Aye.
Opposed? Please proceed.
Thank you so much. Thank you so much to staff and everyone for assisting. You all have heard some testimony regarding this, so I'd really just love to speak to the amendment and what the changes are that we made based on conversation in the committee. The largest change of these amendments occur in section D, going from D to E. So starting with D, and I'm happy if at the will of the committee, if we would like for our staff to read this, then they may want to read this, or I can go through it, whichever you prefer.
Madam Chair, can council preview it for us? Can council preview the changes for us?
That is what I'm processing in request to the patron. Thank you. Yes, please proceed, counsel.
Thank you, Madam Chair, members of the subcommittee. So, yes, the changes are mostly the new subsection E. I did do some reformatting to put the definitions in subsection A, which is proper code form now. The existing law about selling a device is now considered subdivision D. It amends that code section to refer to devices that are designed or intended to deliver a gas containing nitrous oxide through direct inhalation to any person who is not exempt under subdivision E1, and I'll get to that list in a moment. It also adds a new crime for any person to sell, distribute, or offer to sell or distribute nitrous oxide that has or is marketed as having a taste or smell of any food or beverage, including candy, fruit, dessert, alcoholic beverage, herb, or spice, that is distinguishable by an ordinary consumer either prior to or during consumption or use of such nitrous oxide, again, to any person not exempted under E1. So the changes in D would say it's illegal to sell this device that allows you to have direct inhalation unless that person is exempted, and it makes it illegal to sell or distribute nitrous oxide that is flavored except to any person that is exempted in the new list. Those violations would be punishable as a class 1 misdemeanor. The new subdivision E reads, it is unlawful for any person to sell, distribute, or offer to sell or distribute a container of nitrous oxide that exceeds 8 grams except to a list of persons, including a healthcare provider, people licensed or engaged in the business of selling or distributing catering supplies, etc., person or business selling, distributing compressed gases for industrial, manufacturing, or research use, automotive performance equipment, institution of higher education or research institution for scientific or educational purposes, aerospace manufacturing, and propellant for use in food or food prep for restaurants or food beverage services. If you do sell, distribute, or offer to sell or distribute to any person not on that list, it's a class 1 misdemeanor. It is also a class 1 misdemeanor now to attempt to purchase a container of nitrous oxide that exceeds 8 grams unless such person is exempted under subdivision 1. So now we have a crime in front of us in a substitute that is dealing with the device that attaches to the nitrous oxide, bans sale of nitrous oxide over 8 milligrams in a container, and bans sale of flavored nitrous oxide unless people are exempted. All of which would be a class 1 misdemeanor.
Madam Chair?
Please proceed.
Speaking to those, we really worked to try and make sure that we are talking about 3 things: direct inhalation, and that if it is flavored nitrous oxide specifically, not a flavored commodity, we're flavoring nitrous oxide specifically. And in addition, we use the 8 grams, which really encapsulates the larger issues that we're seeing. That is the galaxy gas that we talked about. Normally, those are larger canisters. That's where the addictive behavior comes in, the real issues come in, and then also exempts some of the concerns that we discussed. Those things are under 8 grams. So our safety nets would be that 8 gram, the direct inhalation, and then also making sure we list out the exemptions in E so that we are not encapsulating anyone who is using this legally.
All right, thank you. Are there any questions? Delegate Hope?
Madam Chair, I just want to speak to, do we adopt the substitute?
We did.
We did adopt
we
a
did.
substitute. So here's why this bill's here, is because of the penalty phase. What we're now doing is we're regulating devices on the market for sale. And that is not this committee's purview. So if we act favorably on this bill, it needs to go to general laws because they're the ones that are going to be able to enforce the regulation of a product. There'll probably be some licensing involved through enforcement mechanism there. This is very similar to bills that I've carried on vape. I'm carrying on vape shops, and that's where they go as the General Laws Committee, and they have experience in dealing with the licensing of products and devices for sale and use. So I get why the bill's here for penalties. This is appropriate to talk about those types of penalties, but for the product for selling and distribution in the marketplace, that's a general laws thing. So if we act favorably, it needs to be referred to general laws. Thank you, Madam Chair.
Thank you. Delegate Williams.
Madam Chair, I guess speaking to the Uber chair, I agree with what he just said because I've also got bills that deal with Virginia consumer protection, and this bill reminded me of that. So I agree with you. I would like to see her efforts rewarded so it can keep going forward because she's worked very hard and we've toned it down a number of times to match a bunch of different states. So I would hope that the committee would report and refer.
Thank you. And just to add to all the goodwill, I couldn't agree more with both because it's going to be a matter of how do you enforce not having these on the shelves. When you say offer for sale, you've got to be able to enforce that in a stringent and organized way. Are there any further comments? Seeing none, is there anyone in the audience wishing to speak in favor of? Please all come forward at the same time so I have an idea. All right. Anyone wishing to speak against HB 648? Online, we have one individual who is registered to speak for, and that would be, two individuals, Jessica Dazara? Jessica?
Dazar. Yes. Thank you, Madam Chair and members of the committee. I appreciate all the hard work you all have put into this really important bill. I'm here to ask you, again, for the second time, to please vote yes for HB 648. When I last testified, I shared how my perfectly healthy adult brother nearly lost his life due to nitrous oxide use after it resulted in severe neuropathy and caused him to lose his ability to walk and also feel his hands. I would like to clarify, as Delegate Kent has said, that we're not trying to regulate canisters of whipped cream here. We're not looking for the things that you're finding in the grocery store. Standard cans of whipped cream contain approximately 8 grams of nitrous, and the canisters that we want to stop are straight nitrous. These are sold at stores like vape shops and typically have over a 500-gram capacity compared to 8. They are massive. Vape stores can promote frequent buying of these, and they use phrases like 3,500 puffs and up in their frequent buyer cards, and that is clearly not the intended use of this. I really appreciate the committee taking the time to strengthen this language and ensuring that this common sense legislation keeps a very dangerous drug out of the hands of Virginians. Thank you so much.
Thank you. Mr. Tom Jackson? I'm sorry, forgive me, I looked at the wrong bill. This would be Ms. Jerry Gray Benedetti.
Hello, good afternoon, Madam Chair and members of the committee. I just want to thank you again for working with Delegate Kent, who is my delegate on this bill. I brought this forth to her and started working with her back last April after finding those massive canisters that we're talking about in my son's home. I do believe that this will, moving forward, would be a great bill for the Commonwealth to get these nitrous products off the shelf, and also wanted to give my gratitude to Delegate Kent for bringing this forward to the committee and for all of you for working with her to strengthen this bill to move it forward. Thank you so much.
Thank you. And Council, do you have any comments, concerns before the last word?
No, I think I've looked at every state's law on nitrous oxide, and I think it's appropriate to refer it, and hopefully it can be enforced.
Delegate Kent, would you like to have the last final words before we act?
Thank you. Oh man, the staff has worked so much with me, and they're saying, please, Delegate Kent, stop emailing me, I'm sure. So just thank you to all for working with me on this and keeping something really important alive. And so I'm grateful for that.
Delegate Delaney?
Move to report and refer to general laws.
Second.
As moved and seconded to report and refer to general laws. Any discussion?
With substitute?
With substitute, of course. Open the roll. Members, cast your vote. HB 648 has been reported with substitute and re-referred to general laws by a vote of 10-0, unanimous.
Thank you so much. Thank you all.
Madam Chair.
Yes. Delegate Williams.
I got a text from Delegate Oates, and if I could make a motion, having voted on the prevailing side, I'd like to bring that back up and do it so that we could all change our votes, so that I can then make a motion to strike, so we can vote that it does get stricken.
That clarification.
Because that motion to strike is further down on that list.
I did not want to speak too far for what her desire was. Thank you for that clarification. The motion is before us to reconsider the vote by which we tabled HB 1215. All those in favor say aye. Opposed? The motion is before us. Please.
All right, so now I would move to strike at the request of the patron.
It's been moved and seconded that we strike HB 1219. Any discussion? All those this is a recorded vote? Yes. So please open the roll. Members, cast your vote. HB 1215 is now stricken from the docket unanimously, vote of 10-0.
Thank you, Madam Chair and committee.
And now we have before us is Delegate Zier with HB 718.
Thank you, Madam Chair. I'm offering HB 718, which has to do with warrant versus summons. But I do have an amendment, and I believe that was sent. Does council have the amendment? No. Okay. All right. The amendment is to strike in line 13, instead of other than, instead of or in any class of misdemeanor cases other than class 1 or class 2, it should say involving class 1 or class 2.
Council, would you please report the amendment so we have it accurately before us?
Yes, Madam Chair, and I actually think it should probably say other than class 3 or 4 misdemeanors. That way it would apply to unclassified misdemeanors and class 1 and 2 misdemeanors. So the language on line A should say in any misdemeanor case or in any class of misdemeanor cases other than class 3 or 4 misdemeanors. That's what it should say. Those are the lower misdemeanors, just so we're clear.
Okay, the amendment is before us. Do I hear a motion?
Move the amendment.
Moved and seconded that on line 13, we change it to class 3 and class 4 misdemeanors. Is that correct?
Before we go further, I'm not an attorney, so I don't know the difference between 1 and 2 versus 3 and 4. I'm looking for the arrestable misdemeanors.
Okay. All those, any further discussion? All those in favor say aye.
Aye.
Opposed? Okay, the amendment, the bill is before us as amended.
Okay, thank you. So when someone's charged with a class 1 or class 2 misdemeanor, such as assault and battery, violation of a protective order, sexual battery, stalking, etc., a magistrate may issue a summons to appear in court if the magistrate merely has reason to believe the person will show up in court. And the result has been no fingerprints, no photograph, no entry into the Virginia Criminal Information Network, or the National Crime Information Center, and no way for the next officer or the next jurisdiction to know there is an active jailable charge. The offender walks free until and unless they are arrested for a different, unrelated charge, giving him every opportunity to intimidate the victim, flee, reoffend, or commit an even more serious crime. If a law enforcement officer comes across the offender, he is legally unable to do anything when merely a summons rather than a warrant has been issued. This legislation flips the default to where it belongs. For the most serious misdemeanors, a warrant becomes the rule and a summons the carefully documented exception. And this does not eliminate magistrate discretion, because this simply requires evidence that the accused is both willing and able to appear before a summons is issued. Every summons issued under the exception must be justified in writing and preserved in the court file. Secondly, warrants may already be issued that can allow arrested individuals to be immediately released after arrest. A judge or magistrate can issue a permitted warrant, which permits the officer to arrest an individual and then immediately release them if they sign a promise to appear in court. In other words, when a permitted warrant is issued, if the subject of the warrant cooperates with the serving officer and does not have history of failing to appear in court, then there's a high likelihood that the officer will allow him to remain free until the court date. This then allows the same kind of discretion that's allowed by a summons without the unintended consequences. This change brings uniformity across the Commonwealth, guarantees these charges show up in state and national databases, and most importantly, gives victims the same basic protection we've already afforded in felony cases without adding a single new crime or penalty to the books. Thank you for your time.
Thank you. I'm going to start with questions that I have. So as I'm hearing, you're basically treating Class 1 and Class 2 misdemeanors as we treat felonies?
In essence, and this was brought to me by my sheriff, who said, Eric, we've had folks who we know need to be in court. I see them in Food Lion, and I can't do a thing about it. And so that's the point here, is we want them to be able to, if they know that they're supposed to be in court, to get them there or to make the arrest.
Counsel, what is covered by now? You have to be arrested rather than and come before the magistrate and go through bail as opposed to having a summons. What is now would be covered?
So it would be any class. This amendment would require the police to arrest somebody on any Class 1 or 2 misdemeanor, and then it would be up to the magistrate to determine. So they'd have to be arrested and then have to go to the magistrate and then have to make this showing, and then the magistrate would have to put that in writing. So this would cover driving on a suspended license, reckless driving, those are Class 1 misdemeanors, petty larceny or shoplifting where someone is caught at a Walmart stealing toilet paper and they're caught at the scene. This would cover underage possession of alcohol. This would cover fraudulent license plates. This would cover a lot of traffic cases that we issue summons for. And with regard to what's being said about if you issue summons, there's no ability to process. If the person fails to appear in court on a Class 1 or 2 misdemeanor that they've been issued a summons for, the court will issue a capias for arrest, and that is an arrestable warrant that goes into a visa, and that the police could stop the person and arrest them. And that would be if they failed to appear for their court date. If they appeared for their court date pursuant to their summons, then they'd go through the court process.
Thank you. I see the question was answered. Is there anyone here speaking for HB 718? Anyone speaking?
Yes, ma'am.
Please come forward. Please limit your remarks to 2 minutes.
Okay, I'll try. My name is Dr. Elise Osterweil. I'm the founder of Mothers Reform Trials and Justices, and before June 7th, 2022, when I was falsely arrested for kidnapping my child, who I haven't seen in over 3.5 years, I've been arrested like 6 times. I was in jail longer, for 16 days, for civil charges, longer than my father, who had raped me until I was 8. He only spent 1 night in jail. That experience was beyond traumatizing. I was there without my life-saving medication for my seizures and my PTSD, which are black box warning drugs, and can cause a medical emergency. Even the nurse there was nothing they could do, and I only had to wait and go through all the horrific withdrawal symptoms until I was released, and then it took a very long time to get back on them, and was in and out of the hospital repeatedly, over and over and over and over again. I was arrested for calling 911 to report my ex-husband's stalking because a police officer refused to take the evidence. I was arrested for just calling for help, trying to protect my daughter, who I haven't seen in almost, Wednesday was her 4th birthday, and I got a death threat on my phone 3 weeks ago, too, the day before the session started, and I cannot find a police officer that will help me. I don't have the money to hire forensics, and I'm at risk because I'm homeless, and so I just get picked up, charged with this and that and whatever. Like, for example, I went to court the other day because of my seizures.
So
my
much for
your
testimony. I know that you had given us a longer testimony
But thank you. I support
before,
this
and I do
bill,
appreciate that you appear again before us. Thank you. Is there anyone in the room who wishes to speak against HB 718? Online, we have an individual, I believe, by the name of, excuse me while I get my right piece before me here, Mr. Jonathan Ritchie. Mr. Ritchie?
Yes. Yes, Chair. I'm currently a sergeant with the Campbell County Sheriff's Office, and I have 2 private citizens that had taken out a charge of trespassing and a charge of petty larceny against someone. The magistrate chose to issue it as a summons instead of a permitted warrant. And those summons are almost 2 to 3 years old. Even though it's past the court date on there, the courts have told us we can't return it to them, and we cannot, we just gotta, if we find them, we're told to call them and do a new court date. So there is no show cause, there is no capias, because since it's a magistrate issued summons, they can't issue any of that until that person is served. And it has to be personal service. It's not like a normal subpoena where we can give it to a family member or post it on the door. So these 2 citizens who brought to a magistrate probable cause that they were a victim of a crime may possibly never have their day in court, because on one of them I know for a fact the subject does not live there anymore. He drifts from place to place, and we have no way of finding him because that summons doesn't even go into the database. So he could get stopped for a traffic stop in Virginia Beach, and they would not know, and we wouldn't know. And so my thing is the permitted warrant does pretty much what people want. I am permitted, once I make the arrest, to immediately release you, because there are people that they don't need to go to jail. They will cooperate. I've had plenty of individuals who I did the research in their judgment, and I knew that, hey, they would show up at court. So I took the warrant, gave them a court date, released my signature, and then they show up at court. But if that person had lied and not showed up, then we would at least have the warrant where if they were stopped somewhere, they could be detained. We can't detain somebody just to serve a subpoena or a summons. And that's where I believe this bill would just be very helpful in rectifying.
Thank you. Seeing nobody else wishing to speak, Patron, you have the final word before we act.
Well, I want to thank the committee for hearing this out. And as Deputy Ritchie pointed out, he's much more knowledgeable at this than I am. He's the one that initially had asked me to bring this because they have these warrants that are out there years old, and he just asked, could you do something about this? So, thank you.
We operate by motion.
Madam Chair, move to report.
Second.
It's been moved and seconded that we table SB 18. That is a recorded vote but not debatable. Please open the roll. Please cast your votes. HB 718 is tabled by a vote of 7-3.
Okay. Thank you, Madam Chair.
Thank you. And now I believe Delegate Shin should be next on the list. I'm sorry, Delegate Walker is actually next. Sorry, coming back to Shin. So Delegate Walker, you are on the list for 1027. I believe we have an amendment or...
Yes, ma'am, Madam Chair, you should have a substitute before you.
Move substitute.
All those in favor say aye.
Aye.
Opposed? Substitute is before us.
Thank you, Madam Chair. Under the current law, the online solicitation statute is written so broadly that it can apply when any person poses as a child online. That has led to many private individuals who run their own online sting operations, confront suspects, and record with encounters and then attempt to turn the material over to law enforcement. While some may believe that they are helping, these activities often create serious problems. An untrained and unsupervised evidence may be compromised. Ongoing investigations can be disrupted, and the public confrontations can potentially put witnesses and innocent people at risk. Our system does not allow citizens to conduct undercover drug buys or traffic enforcements. It should not rely on private citizens to conduct undercover and child exploitation investigations neither. HB 1027 clarifies that the online solicitation statute applies only when persons being solicited is an actual child, a law enforcement officer acting in an official undercover capacity, or a parent or guardian acting to protect their own child. It does not protect offenders and does not stop citizens from reporting these serious issues here. This bill keeps every legitimate law enforcement officer's tool in place to pursue and prosecute child predators, while removing the innocent and unauthorized private sting operations that often do more harm than good. Madam Chair, this is a bill that I was asked to carry on behalf of ICAT. That's the Internet Crimes Against Children, which has been operating in our neighborhood for many years now. And so we hope it'll be the wishes of the committee to move forward with this. Thank you.
Thank you. Is there anyone on the committee that has any questions? I'd like to speak. Delegate Delaney.
Thank you, Madam Chair. And this is a question for the patron, or if there is someone from the ICAC task force on hand to answer if they had help in crafting this language. But I feel like a parent or guardian of a child within the age range is described or prescribed in this section is incredibly broad. Many parents traffic their own children and are sometimes part of exploitation. And so I'm wondering if someone could comment on that broad language that could, just reading it plainly, seems to kind of give immunity for anyone who just happens to be a parent of a child.
I'm not an expert in this, so to try to answer your question, I think while there are people attempting to do good things, I think the parents or guardians are trying to look out in the best interest of the child that may be potentially being solicited here. I don't know if that answers your
Follow-up question, Madam Chair.
Mm-hmm.
I'd hope many parents would, but unfortunately, many parents are the exploiters of their children. And many of the crimes that we see, examples of exploitation, trafficking, and CSAM, unfortunately, do come from parents and guardians. Mm-hmm. And so I would be concerned, and I don't know if council has an opinion on the choice of language here, but this just seems incredibly broad and immunizing of those bad actors who also hold the status of parent.
So you specifically, counsel, if you could comment on Romanet 2, starting on line 58.
Yes, Madam Chair. I'll just comment on the language, and I'll let Ms. Paulus talk more about how this would kind of work in practice. We did look at other states, such as Ohio and Florida, when crafting this, and it does appear that there is some language about the involvement of parents and guardians in those states. The intent of it was to say if a parent or guardian finds out that their child is speaking to someone online, and then they start speaking to that same person and trying to get that person to say, basically, your parents trying to scare you straight, seeing that you're talking bad online, and then see, look what this guy wants to do to you now. That would then be covered. Originally, we were discussing, though, if you were already talking to the child and then the parent takes the phone, you should be able to take it to a law enforcement officer at that point. But it might be harder to prove that the person speaking at that moment had the lascivious intent to do any of the actions listed in that section, depending on how long the conversation went. And I'll let Ms. Paulus continue.
Right, and to Delegate Delaney's point, subsection F is referring that this section shall apply. So if you are a parent, it would apply to you. So meaning you could be prosecuted, I guess, if there was confusion. This is not an exemption. The only way you could be prosecuted under this section is if you were communicating with a child, with a police officer posing as a child, with a police officer posing as a parent or guardian of a child, or with, if the perpetrator is corresponding with a parent of a child that's posing as the child. So in this scenario, you could be prosecuted under all of these. I guess if that makes sense.
Delegate Delaney?
Thank you, Madam Chair. So yes, that does make sense, and that's kind of the clarity I was looking for. And so just because we just got the substitute, so I hadn't completely processed what that was referencing. So I'm going to restate what I think I just heard counsel say, just for clarification, that this is not necessarily giving immunity to law enforcement, et cetera, et cetera. This is saying that these are the cases where a bad actor could be prosecuted. And that would now include if they were talking to the parent of a child rather than the child themselves.
Yes, this is just to clarify that a defendant who is communicating with to catch a predator type person, they couldn't be prosecuted then if they're like, hey, come to this location and I'm going to post it on social media. I think the whole point, is my understanding, is that police officers were then having trouble prosecuting because it was through third parties and chain of evidence. And so that was the goal of this, not that perpetrators would not be prosecuted. It's just that we would only be prosecuting people who are actually directly communicating with a child, their parent, or police officers in these stings posing as a child or a parent. That's my understanding of the goal, and that's the language that was attempted to be used.
If I may,
actually, counsel does a better job trying to explain.
If I may,
so thank you.
Go ahead.
No, I was just saying thank you because that's where I was trying to go, and I think that helps.
Thank you.
Delegate Delaney. Thank you.
Thank you, and I appreciate that you appreciate where she's going, but I have the same concern that Delegate Delaney started out initially, that you are allowing, even though, as for example, on line 20, it says it's unlawful for any person 18 years of age or older to use a communication device, etc. We're saying, oh, but you can go ahead and do it if you are a parent that is posing as your child. And this is where Delegate Delaney's concerns about parents who are exploiting their child are, in fact, while they're not changed in the law itself, I would have real problem that they're changed in this exception that you're trying to go after as far as vigilantes, that it's going to be interpreted that somehow this person is not guilty under the law itself for posing as their own child in an exploitive way.
They would be the accused in that situation, so they would be prosecuted. It's the person with whom the accused is communicating. So if they are a parent trafficking their child and reaching out to people, they could be prosecuted. This is just trying to clarify that the person the accused is communicating with are either an actual child. So they would be prosecuted under this code section because the person they're communicating with is either another child, a police officer, or a parent of that child posing as. So they would be prosecuted. This doesn't create an exemption. It says this provision only applies if the accused is communicating with these people. So if they are the accused, they would be prosecuted, I guess, if that makes sense.
As I had recognized myself, I'm going to say It sends a confusing message. There is no reason to exempt this person under this provision and send a confusing message that somehow in the body of the law itself they are not included. So that, I believe, is the issue that is before us. Delegate Williams, then Delaney, then Schmidt. Delegate Williams.
Yes, Madam Chair, this has been very confusing, so I asked somebody else, and I want to read what has been returned to me. The key change is in subsection F. It defines who the accused must be communicating with for the statute to apply. The substitute adds this clause. It says a law enforcement officer posing not just as a child, but also as a parent of a guardian of a child. And what I'm going to get to here is because I happen to watch a lot of the new Chris Hansen To Catch a Predator. He's got a new show on YouTube, To Catch a Predator. And what they will have is they'll have some woman, confidential informant, posing as like an aunt. And she is soliciting. She's soliciting.
She is an informant with law enforcement?
Yeah, so the aunt would be like.
So she's covered under then Roman net.
Right, but what they're having an issue with is prosecuting the accused because they're saying that they're speaking to an adult. They're not talking to the child. If they were speaking to the child, they're going to get prosecuted. That's the issue that they're having that this is trying to fix. This closes a gap in sting operations. If an officer poses as a parent offering access to their child rather than posing as the child directly, a defendant could argue that the statute doesn't reach the conduct as posing as a child. I think that's what it's trying to do, but it's very awkward.
Was that a question?
Nope, okay. That's just me saying how I feel.
Thank you. The next one on the list then is Delegate Delaney.
Thank you, Madam Chair. Yeah, I'm trying to kind of quickly process this substitute, and I don't know if there is someone online that's with the ICACs. I'd be kind of interested in hearing kind of their intent with this because they are amazing and definitely need more resources. But it's already unlawful to do this communication, so I'm just trying to understand like exactly who we're trying to add to the ability to prosecute. Who currently can't we prosecute that this is now allowing? And it does just kind of give the impression that we are kind of saying that parents can be the vigilantes, like that's kind of, and maybe I'm just not reading it correctly, but there's the structure to the way this is written that I'm still unclear who exactly we're getting at, and the parent part is just kind of leading to extra confusion with, are we saying that because the parents are able to communicate, and now the predator could be prosecuted, that we are kind of saying, yes, To Catch a Predator events can't happen, but unless it's parents, they can be vigilantes. And so there's some confusion that I have that, I guess maybe this is a bill to carry over because I want to get this right. Making sure that these predators get prosecuted is important. Making sure that the ICACs have the tools that they need to prosecute the mountains of referrals and tips that they already have is super important, and I'd like to help with that too. So I know we've got testimony though, but I'm kind of contemplating if we could carry this over potentially to next year, but I guess we have to follow the process here.
Thank you. The next speaker is Schmidt, Delegate Schmidt.
Thank you, Madam Chair. I'm also trying to figure this out, and maybe this is a question for council, but so in this scenario, like generally when we're talking about crimes forming the criminal intent, the act is on, the actions and the act is based on the perpetrator, the person that's doing it. So this is saying that if someone is online intentionally soliciting, that unless it is actually a child, a parent of a child, or an undercover law enforcement officer, that they get a pass. Yeah, for counsel.
That is the amendment, yes. And my understanding is the goal was to eliminate third parties who are trying to do their own stings.
I understand that.
Yeah, but technically, yes.
We are blowing a hole in the statute by giving people a pass that are forming the criminal intent, going through the motions of soliciting, and just because it is not who that person thinks it is, we're giving them a pass. And I don't think we studied this or carried over. I would also like to hear from ICAP and figure out, what the issue is, and maybe there's a different way to approach this issue. Thank you.
Is there any response? Thank you. Did you want to bring someone online to ask a question, or you want to hold it until? If you can go ahead and allow the representative to come online so we can ask questions. And I am recognizing then Mr. Stephen Anders from the Bedford Sheriff's Office. If you could respond.
Thank you, Madam Chair and members of the committee. I appreciate the opportunity to speak with you today. In regards to the questions that were brought up by Delegate Delaney and some of the others, the primary motive behind this update to the language is right now, the catch predator was mentioned earlier, and that is something that we're all familiar with. I was actually a watcher of the show before I got into law enforcement. And a little bit about myself, I've been involved in ICAC work full-time since 2008, so 18 years full-time investigating and prosecuting these types of cases, and now currently serving as the commander of the Southern Virginia ICAC Task Force, which is one of 2 ICACs here in Virginia. What we're seeing now is a very large increase in what we call cyber vigilante activity. These are now a lot of copycat groups that are trying to model themselves and be inspired by the catch predator, but they are a lot of them are motivated by monetization of their social media and video posts and confrontations of offenders, and then trying to, once they get their material that they can post online for ad revenue or to sell merchandise or solicit donations, then they try to turn it over to law enforcement. A lot of challenges that our agencies on the task force, actually both task forces and even agencies across the country and the other states struggle with is there's a lot of due process issues. There are challenges with evidence. Is it the original evidence? Is it unaltered evidence? Are there entrapment issues? We can't verify sometimes who the actual chatters are. They're chatting in other states. There are jurisdictional issues. They will often set up meets and confrontations in a jurisdiction where neither the offender themselves lives or where the vigilante, the person doing the undercover chat, was living. So then they create a public safety issue when they do these confrontations and takedowns in different communities. We've seen them in libraries, we've seen them in schools, we've seen them in parks. Recently here in Virginia, there was one that they posted a video that looked like they were at a high school football game in the gymnasium during a high school basketball game on school property with students around. There have been vigilante issues across the country where it has turned violent. Either the vigilantes assault the alleged suspected offenders who have not been charged or convicted yet, but also some of them have been injured and killed by those offenders. We in law enforcement routinely deal with suspects that are armed because they know what they're doing is dangerous and they're very likely to get caught. I know North Carolina a couple years ago had an instance where—
Mr. Anders, I thank you for your comments, and they have been very excellent in laying out what you're dealing with. But I believe that we had a specific question we do not have from Delegate Schultz, how this bill directly affects your issue, but I see that Delegate Schultz does not have a follow-up question. So I thank you for giving your testimony in support of this bill. Is there anyone else in the room who wishes to speak in favor of HB 1027? Anyone wishing to speak against? Then let us return then to our discussion that we were in the midst of, and I believe the next one I have in line is Delegate Williams. Delegate Williams?
Yes, Madam Chair, that testimony helped us understand what the goal was. I feel like we on the panel now know what we're trying to do. This bill doesn't do it. So I would like to move whenever he gets the last word, but move to carry it over because we know what you're trying to address, but that doesn't do it.
I'm more than willing and acceptable to that.
Thank you very much for that answer. With that, I'm going to go ahead and recognize Delegate Williams. Delegate Delaney, did you want to speak?
I'll second Delegate Williams'
Okay,
motion.
it has been moved and set by Delegate Williams, seconded by Delegate Delaney, that we carry over HB 1027. Carrying over, I always have to, is a voice vote. All those in favor say aye.
Aye.
Opposed? Thank you, Delegate Walker.
Thank you.
Now Delegate Shin. And Delegate Shin has before us HB 1464.
My favorite thing about these podiums is that they move, Madam Chair. Madam Chair and members of the subcommittee, there is an amendment, I think, that might have been prepared.
Second.
All those in favor say aye. Opposed? Amended is adopted.
Thank you, Madam Chair and members. The amendment eliminates Romanet 6 on lines 218 through 221 or 220. 220. And then I will explain what's before you, because over the past couple of years, I've been working on the issue of expanded access to care for survivors of sexual assault, and it seems to be an issue that lots of my colleagues, especially on this dais, care about. House Bill 1464 sets out to accomplish three primary things. First, it seeks to expand the Criminal Injuries Compensation Fund's authority so that in addition to the Physical Examination Recovery Kit examinations, or PERCs, physical evidence, I'm sorry, it's not examinations, physical evidence recovery kit examinations, often called PERCs. The fund could also pay for anonymous trace evidence collection kits conducted on victims of strangulation. Right now, trace kits are being administered to victims who are cooperating with right now, trace kits being administered to a victim who is cooperating with law enforcement are being reimbursed for by OES, but ones that are anonymous are not currently reimbursed, and so this would permit for anonymous trace kits to be reimbursed in instances where the victim may not yet or potentially ever cooperate with law enforcement or pursue charges. I think that this protects the victim's options and honors their autonomy to control their own timelines and their own decisions. Second, this bill adds the requirement that the coordinator of the Virginia Sexual Assault Forensic Examiner Coordination Program be a registered nurse. And finally, the enactment on this bill sets up a work group for a comprehensive review of streamlining reimbursement processes. Delegate Delaney introduced House Bill 1731 last year that established a work group. And the work group that's established in this enactment clause, I hope you all will consider a continuation or a legacy of that work group in thinking about how to streamline these reimbursement processes. One of the conclusions from that work group, Delegate Delaney's work group, was that they'd concluded the bifurcated forensic exam reimbursement system between the Supreme Court of Virginia and the Virginia Victims Fund is complex and may result in delays, complications, extra work, or unequal reimbursements. And so this is a bill we hope will strengthen Virginians' access to critical forensic nursing services while improving efficiency and accountability in the reimbursement system. Thank you, Madam Chair and members of the subcommittee, for your consideration.
Thank you. Delegate Delaney? Oh, that's from the previous bill. Thank you. Is there anyone who wishes to make any comment, ask any questions of council? Is there anyone in the room wishing to speak in favor of HB 1464? We have two coming forward. If the two of you could split. Obviously, we have another one, so if you could still split 3 minutes, please.
Yes, ma'am. No, I know I'm standing in between y'all on the weekend, so I'll be brief. Madam Chair, members of the subcommittee, I'm Hannah Coley with the Virginia Hospital and Healthcare Association, speaking in favor of the bill. Thank you to the patron for all of her thoughtful work on this as we got this together. Briefly, access to forensic nursing care is limited. There are fewer than 200 providers statewide. These access challenges are worsened by a fragmented reimbursement system that's burdensome and in most cases contingent on the victim filing a police report, something that's not always safe or possible. Hospitals and nurses provide care regardless of law enforcement involvement, and we believe that reimbursement should reflect that reality. Aligning reimbursement with stabilized programs, support the forensic nursing workforce, preserve critical evidence, and ensure access to trauma-informed care when patients need it the most. So for those reasons, we respectfully ask for your support.
Thank you.
Good afternoon, Madam Chair and members of the committee. Jennifer Foster, representing the Virginia Sexual and Domestic Violence Action Alliance, a coalition of 70 sexual and domestic violence agencies across the Commonwealth. We are grateful to Delegate Shin for bringing this bill forward. This bill is a product of a multidisciplinary work group that includes the Action Alliance, sexual assault nurse examiners, and system partners. We are happy to have been a part of the work group and the bill that it produced in providing that trace evidence collection kit examinations conducted on victims of strangulation be paid for by the Virginia Victims Fund, and stating that victims are not required to participate in the criminal justice system or cooperate with law enforcement authorities in order to access this benefit. This bill eases the burden on victims of strangulation and increases the likelihood that victims will cooperate in forensic examinations. We wholeheartedly support this measure and urge the committee to pass the bill. Thank you.
Thank you.
Hi, my name is Elise, Dr. Elise Osterweil of Mercy, and I strongly support this bill. But I would like the committee to consider updating the definition of what strangulation means, since up to half of strangulation victims don't actually exhibit any kind of external injuries, like myself when my ex-husband had attempted to strangle and rape me. And so, and then sometimes, victims, because of their fear of death, they don't report right away, hence there's no medical examination or evidence that can be captured in order to prosecute. So I think this bill is a step in the right direction, but I do think that strangulation does need to be better defined, as well as in conjunction with coercive control, which usually they come together.
Thank you. Is there anyone in the room wishing to speak against 1464? And I have no one online. Council, in discussing any comments, the strangulation is one that's been interpreted as we have it here in this code appropriately?
There is a code section on strangulation that defines it, yes.
Thank you. Delegate Shin, you have the final word.
Oh, I just wanted to say thank you so much for your continuation and for the subcommittee's ongoing work on this issue. It's really important, and I thank you all for your work on this.
Okay, thank you very much. So now it's time for committee discussion. Delegate Davis.
I just have a question for the patron. Do these costs get taxed to the defendant when he's convicted, he or she is convicted? And if not, why?
I'm not familiar with how Madam Chair, I'm not familiar with how the criminal injury compensation fund is funded, but I assume it is through some of that. But I hope council might be better equipped to answer that question for the delegate, Madam Chair.
I'm not 100% sure, but because this bill is including anonymous trace evidence kits, if there was never a prosecution, it would be paid for by the Commonwealth. If there was a prosecution, I don't know if this specific cost would be attributable to the defendant. I think it would still be paid for by the Commonwealth because I don't think it's part of court costs. But this would be allowing for people who are anonymous and may not want to go forward to be paid for by the Commonwealth.
Thank you, Council.
If I see the overchair isn't here. The Victims' Compensation Fund has been in existence for a significant period of time, but I'm not sure of all of its sources of funding. But I think that this is just extending victims' definition. Yes.
Madam Chair, thank you for saying the Victims Fund. So that's the colloquial name that's been changed to, but it's actually known as in the code, Criminal Injuries Compensation Fund. And it does say in subsection B, whenever costs are provided for in 7 relevant code sections and 2 subsections of another code section, that a portion of those costs as specified in those code sections do go to this fund. So to Delegate Davis's question of whether some of these are from the defendant, those court costs would be listed in those code sections if the relevant charge or whatever was going on with that case was part of those statutes. So it is some funded from the defendant.
As appropriate. Thank you.
Thank you.
Are there any other questions? Concerns? We operate by motion.
Move to report as amended.
This would be a report and refer, and of course it's as amended.
Yes, and refer. Yes, naturally.
Clerk, please open the roll. Members, cast your vote. Okay, HB 1464 is reported and referred as amended to appropriations by a vote of 9-1.
Thank you so much, Madam Chair, members.
It's not for me.
And then we return then to the docket as it appeared before us. And now for members of the committee, Delegate Cousins, 862. Who did I miss? Thank you. You got in just under the wire. Delegate Sewell. And this would be HB 1219.
Thank you, Madam Chair. Before I present, I do wish to flag for the subcommittee that I have a substitute, and I printed off copies.
All those in favor say aye. Opposed? Substitute is before us.
Listen, I didn't even know I was coming. You guys are so on top of it. You had copies for me. Well, thank you, Madam Chair. House Bill 1219 is a public safety bill that will provide a narrow targeted expansion of the use of unmanned aircraft systems in emergency response and requires the Criminal Justice Service Board and Department of Criminal Justice Services to establish a model policy for the operation of unmanned aircraft systems and post it to the department's website. Currently, while law enforcement is able to use unmanned aircraft systems, more commonly known as drones, in cases of amber, blue, and senior alerts, there is no mechanism for their use in response to an emergency call without obtaining a warrant. Functionally, this means that these information and delivery devices are unusable by law enforcement, fire, and EMS in dire public safety emergencies such as a house fire, a school shooting, or urgent public safety calls. House Bill 1219 will establish clear and limited cases in which drones as first responders may be deployed for rapid situation assessment, criminal scene documentation, and essential supply delivery. So what does the bill do? It allows for real-time aerial observation by law enforcement of law enforcement events in response to emergency calls, allows for essential supply delivery from drones during emergencies, whether we're talking about Turner kits or Narcan. It allows on-scene communication for officers en route to a 911 call, and it allows for documentation of a crime scene on public property in response to a public safety call. It allows for use of a drone without a warrant in cases of fire and rescue. Currently, the language only explicitly notes in the code that it can be used in response to a wildfire only. And lastly, it grants authority to the Department of Board of Criminal Justice, as I noted, to create that model policy, ensuring that we're ensuring best practices across the Commonwealth of Virginia. And now it's equally as important that we highlight what the bill does not do. It does not expand drone usage without a warrant in non-emergency cases. It does not permit searches of private property and documentation of non-public spaces without a warrant. The bill does not allow for mass surveillance or arbitrary digital documentation. And it does not permit the use of facial recognition or biometric software on drones. That section of the code is scheduled to expire the same day that this piece of legislation could become law. And it does not change the prohibition on any weapon being utilized on a drone. So in short, House Bill 1219 will allow for law enforcement to have the best information possible during the most dangerous situations the public can face, and will allow for the use of tools that have been proven to be both effective and de-escalatory. And drones as a first responder have clear success all across our nation. This technology has saved lives. It has been utilized with strict professional oversight and clear guardrails, and can have a strong public safety and serve as a strong public safety tool here in the Commonwealth as well. Thank you, Madam Chair.
Thank you for that explanation. Are there any questions, concerns? So essentially, in the substitute, we're looking essentially at the last 3 pages where you have both said DCJS will do model policies, and you've made specific additions to when it can be used without a warrant.
Correct.
Thank you. Are there any other questions? Then we are ready for testimony. Yes, Delegate Schmidt, I'm sorry. Forgive me.
Thank you, Madam Chair. I guess I have a question also for, I guess, council. I guess I'm wondering what the difference is when you go to 19.2, when you go to the Drone Act, 19.2, 60.1, under C, C4, it says where use of an unmanned aircraft system is determined to be necessary to alleviate the immediate danger of any person. I guess my question is, and then the language after that obviously is where we're including providing drones without a warrant for response to emergency calls. I guess in the examples that were used, is there some confusion or conflict in the general warrant exceptions that exist regarding imminent danger to someone? Like, in other words, are we duplicating language when we say the code already says immediate danger to any person? Does that encompass exigent circumstances?
I think you could potentially read it that way. I think the purpose of including that additional language in subsection 4 was that police officers were told they had to get warrants and they couldn't serve it on anyone because it was on a highway or something like that. So that was to kind of clarify. Arguably, I think immediate danger to any person could encompass the additional language in 4, but there were also the amendments that were added for crime scenes on public property and things like that they would have otherwise had to get a warrant for. But we limited it to public property so that they wouldn't need a warrant to document a crime scene on public property or calls for service. And then same with the amendment in B2. I think the issue for law enforcement was the example given to us was someone might be breaking into someone's house and running away with stolen property. The police, a drone could get there faster and follow the person as an officer is en route, which is why we use that specific language. If someone's on public property running from the scene of a crime, a drone could be used to kind of get there quicker. So some of the stuff I think arguably would already be encompassed by 4, but the additional language of the amendment I think was to cure concerns of law enforcement in the ability to do their job on public property, which is why it was limited, because I did have Fourth Amendment concerns originally. It didn't carve out public property. We had concerns about curtilage of people's homes and crime scenes in backyards, which is why the substitute has been presented. If that answers.
Yeah, that answers. Well, just a follow-up question. In your example about somebody commits a robbery and is running away, is that covered by the C, where is that? Online 405, like locate a person sought for arrest when such person is fled from law enforcement, the hot pursuit.
Right, so it wouldn't cover hot pursuit in C because it says specifically running away from a law enforcement officer, which is why they wanted the amendment.
Gotcha.
That this would include if the officer is not there yet, but they are running away from a crime.
You can deploy the drone before the officer is in
before the
pursuit.
officer gets there to track a person on public property to locate them.
Okay. And then a final question, or at least
Please proceed.
Sorry. Thank you, Madam Chair. So when we say in response to emergency calls, these are all calls to 911.
That would be an emergency call, yes.
Right. So all calls to 911, police without a warrant can dispatch drones.
If it's on public property for these specific reasons.
Okay. Thank you.
Yes.
If I may follow up before recognizing anyone else, to clarify what I thought I was hearing in the exchange, is that it's limited for the purpose of locating and identifying any person of interest. So anything else that is recorded by that drone would not be usable in evidence. Is that correct?
that maybe is a bit more complicated of a question. If they're using the drone legally in compliance with the statute and they happen to see things that are in plain view, the plain view exception to the warrant requirement would apply, arguably, and that's probably something that would have to be litigated in court. But if it's being used in compliance with the statute and something is seen in plain view and they obtain evidence based on that, potentially that could be used in court.
If I could follow up,
Yes.
But the language that the legislature has before it, we're only extending this for the purpose of locating and identifying any person.
That's what the
so
language says.
We're not authorizing it for any other purpose.
Correct. So as long as something wasn't viewed en route to that location, it's a little bit complicated with the Fourth Amendment analysis, but the goal of the language was that it would only be used for that purpose to locate a suspect on public property.
On this case, I'm looking at 407, which is not about public property.
Which section, I'm sorry?
I'm looking at line 407, where we're authorizing it for, I'm sorry, it does say public property incident. My apologies. Okay, thank you.
Yes, thank you.
So now I have Delegate Hernandez.
Thank you, Madam Chair. Question for council, just to put a fine point on this, and I'm sorry to always ask Fourth Amendment questions, but so I understand this substitute is trying to narrow the scope, but just so I understand, so if a drone is following an incident and happens to see evidence of a crime or crime taking place, let's say on private property, en route, because the drone is in the sky, that probably falls under the plain view doctrine. But my question is doesn't everything become plain view when you are a drone flying in the sky?
That's a good point, and it's a very complicated issue, and we're going to get to the, like you said, if they see something on private property while responding, arguably that would be in plain view. Is that a certain, I mean, it's really complicated. I don't necessarily know how to answer your question. We tried to limit it, but yes, your concerns are valid, and potentially if it's flying over my neighborhood because someone broke into my house, but they see something in my neighbor's backyard that otherwise might be protected by the Fourth Amendment, and they use that to then get a warrant to search the house, yes, that evidence could potentially be admissible
Madam Chair.
without use of the
Delegate Hernandez.
Yes.
So then, based on that concern, which does seem like a concern, is there a way to remedy that with language, or no? Just
I don't know how it could be, because drones can see a lot more. We tried to limit it to public property to achieve the goal of the patron, but also keep in line with the Fourth Amendment. It's really complicated, and I understand the concerns, and I'm sorry if I'm not answering the questions. There's no case on it yet.
If I may follow up on that line of questioning. So we've already got in there that anything that goes beyond the purpose of the warrant is not admissible in evidence. So is there any way that we can bracket to what is not admissible in evidence that might be in plain view in what we are authorizing?
We may be able to, I would have to talk to Mr. Hatcher and the patron, but there is an exclusionary rule in the statute currently that if the police don't get a warrant for a drone, that evidence can't be used. Perhaps if evidence is discovered in violation of these amendments or something, like perhaps we could massage some language to also include a statutory exclusionary rule, because under the general Fourth Amendment exclusionary rule, I think the evidence would be allowed. I think the legislature would have to create that exclusionary rule. And I can't think off the top of my head of the best way to say it, but there might be a way that we could think of it. Mr. Hatcher?
Madam Chair, members of the subcommittee, I think that the problem that I'm having to try to even figure out some language is you're basically saying you're allowed to send this drone out into the air, but now we need to say you can use it for these purposes, but now they have to turn a blind eye to anything they see. If a law enforcement officer was following you into your house under exigent circumstances or hot pursuit, and they pass your bag of coke on the table, you're now going to get charged with running from the police and possession of a drug. They can't turn a blind eye to it. So I don't know how we proverbially let the genie out of the bottle or put it back in the bottle with this type situation. We're hoping and praying, I guess, that law enforcement would use it correctly. The same conversation that we had with the DEQ conversation, which was the drones are only going to be used for civil enforcement on permittees that they have authority over to enter the property. Here we were saying you're only able to send the drone out into the public property. If they see someone shoot someone on the street, that's public property. That would be evidence that they could admit under this statute as a crime. If they see something in your backyard, but they were on the public street, arguably maybe it would be admissible. If they go off the public street, enter the airspace, whatever, over your house, because we do have a different statute for drones about being 50 feet within with the intent to harass or coerce, and then they see something in your curtilage or in your backyard, okay, that would be a violation of the statute because it's supposed to only be on the public property. But that's about the best that we can give you at this moment because, again, there's no cases it's too advanced for the court to have caught up on it the way litigation goes.
Delegate Hernandez.
Thank you, Madam Chair. It's not really a question. I think I have some concerns because I think drones are different. I think it's different than a scenario of law enforcement walking down the street and seeing something because drones are in the sky, and so what they're able to capture is potentially vast. And so I'm searching for a limiting principle, but maybe there's just not one yet. It's so novel.
Delegate Delaney.
So question for council, my understanding with the drones, it's kind of a gap between the time it takes to send up a helicopter, but there is precedent for airspace being used in these types of pursuit by a manned aircraft or personed aircraft. Some women are pilots too. So what happens in those scenarios where you've got, a vast line of sight from the sky? I mean, that's long established precedent. How does it compare with manned aircraft?
Right. So there is Fourth Amendment case law about aircrafts, and if they're flying pursuant to FAA regulations, and it's something that they could see with the naked eye, then that's not a violation of the Fourth Amendment if it's open to the public, even if we're above your backyard. The difference between drones, and certainly there might be people who could explain this better than me, is they can fly lower and they can record and they can see more than the naked eye. So there's not case law on that specifically. There is an airplane and helicopters can fly lower if you see it, but they're not recording it and they can't zoom in. It's just naked eye. Then yes, that's not protected by the Fourth Amendment because somebody who has their own airplane who's flying within FAA regulations could also see that as citizen. So it's what is exposed kind of equally to the citizenship. And then do the police have advanced technologies that are not as open to the public? And that's what we got with the case where there was the thermal imaging that they could see the heat and see people growing marijuana, and Justice Scalia was all upset about whether they could see if his wife was naked inside because she was moving and things like that. So it's all about the technology and who has access. So these things are complicated, but you're right, normal aircraft, naked eye, not covered by the Fourth Amendment. This is a little bit different, but there might be somebody who could explain the drones a little better than me. But.
Madam Chair?
Yes, about the patron.
Yes. So I actually had the chance to see these drones in action, and I was looking back behind me because I can see that we have Chief Emeritus Charles Werner, who's on the line. The drones take off and go up immediately straight up into the air, and they're flying well above sight of land. So I'm happy to turn it over to Chief Werner if he would like to answer that question and talk about the application and the usage of these drones and many of the policies that have been implemented in other localities where these drones exist, to include Montgomery County, which has become like the standard bearer for a lot of the protections around the Fourth and First Amendment.
I would be happy to answer, to recognize Chief Pavel
Werner. Charles Werner.
Oh, I'm sorry, Charles Werner. But for the purposes of answering questions, we're not taking testimony at this time.
Correct.
Do you have any clarification to some of the questions that you have heard?
Yes, ma'am. I think that the bottom line is when we take off from the docking station. These are operated remotely, and they're typically aimed straight ahead. They're not looking down until they get to the mission at hand. I think that the way to address this is really through the model policy through DCGS to be able to go into more definition of how we want these drones to operate, which can give further guidance. Typically, they are recording from the time that they take off till they get to the scene, but they are not being done so in a purposeful looking down mission. So again, I think that the way to address this is through DCGS model policy. And that is in the best practices currently that's recommended.
And Madam.
Thank you. Seeing Delegate Williams.
I was going to ask a question of Patron. Can we not turn off the recording until they get to the site? I mean, like, what are we trying to stop from being seen? Or like, what is your goal here?
No, so I will refer back to Charles Werner about that question. So some localities have established policies where the drone is unable to record until it gets to that particular location. Some localities have them only perched on buildings that are X number of feet in the sky so that they are well above, again, the ground and are unable to have any view shed of like what a community or a backyard may look like. It all depends upon what we put in that model policy, and I don't want to pretend like I'm the expert when it comes to what that should look like. We also do have another expert on the line who is from Prince William County Police Department, who's also maybe able to offer some additional insight as to like what that model policy should look like.
Okay, I would recognize Mr. Pavel to answer the question.
I mean, there's separate policies that each jurisdiction can implement, but yeah, we can definitely not be able to record until we get to the particular incident or address that we're flying to.
Thank you, and my apologies, Ms. Purple, for not realizing Jamie was a female name. I'm so glad to have your service. I'm still coming back, now recognizing myself, I'm still coming back to the problem. We're looking at a section which says you don't need a warrant for the following uses. So just because it's flying in the sky, maybe it's on the way too, and who knows what it sees and records. I know we went through this debate when we first had red light cameras. Those cameras are there, the eyes of the officer, therefore it's a valid citation for running a red light because we said it was the eyes of the officer used for that purpose. Now, I know we use all kinds of cameras that are with establishments when we're trying to investigate a crime, and I understand that, but I'm very concerned that this can't be interpreted as I see the bright words on the page, for the purposes of. And if you do anything other than what the warrantless use of that drone was, that purpose, then the evidence is inadmissible. I don't see that it's just the officer walking along as a comparable, what the eyes of that drone are seeing are comparable to an officer walking along and observing a crime.
Madam Chair, we are all collectively in agreement that there's a lot of stuff that we're going to have to address to like accomplish what she's trying to do. But we're willing to do that. There's no way we're doing it tonight. So, I just want the patron to know, like, we hear you. We're working on some stuff, but I mean, I personally can't support it right now, but we're trying to figure out exactly what you'd like to do.
Delegate Cousins.
Thank you, Madam Chair. I do have a question for the patron. So, Delegate Soule, you mentioned the model policy in Montgomery County. And so I'm wondering if there was similar enacting legislation in Maryland that sort of created the ability for their equivalent department to create this model policy. And if maybe you can talk a little bit about how this is similar or maybe different.
So I'll just simply start off by saying, I'm sorry, Madam Chair, I'd respond to the delegate, that the Commonwealth of Virginia was known as the lead when it came to unarmed aircraft systems, and in particular use by law enforcement. But the technology has not kept, the code has not kept up with the technology. So there are other states all across the Commonwealth, there are other states all across the United States, it's late, that have been able to implement similar policies to like what we're trying to do here today. California is an example. Maryland has examples. I referenced Montgomery County in particular because I saw it in action. And again, it has become the standard bearer due to their level of transparency. They even go as far as to have a website that is set up that not only showcases model policy, but it also allows for individuals to follow the drones and to see what the video footage looks like. So that is all publicly available information, and they even provide what was the initial call that was made, as well as what is the end result for the action that transpired. I don't know if there's anything else that Chief Emeritus Werner would like to add to that conversation, or if there's anything that the Prince William County Police Department would like to add as well. Everyone, you guys want me to answer at this point?
Without
this providing testimony.
I see I have Delegate Schmidt who'd like to be recognized, and then we'll take testimony.
Thank you, Madam Chair. I guess my concern is still that we're talking about policies and model policies, but it's, the policies are running up against constitutional concerns that we've addressed. So I think, it is late, and if we're going to do this with a work group or try to figure out how we get to addressing particularly the problems that I want to see addressed. I mean, fire, emergency response, crime scene investigations, making the job easier for law enforcement to do that. All of those things, my concerns are still that it becomes sort of the blanket. We can send out a drone whenever we want, and we're viewing all this other stuff, relying on policies rather than, law or making sure that we're not in violation of the Fourth Amendment, since we don't have guidance on much case law. I agree with the code has not kept up with case law. I mean, the code has not kept up with technology, and neither has the case law on this. So I don't know what the answer is, but perhaps we can work on this and get it where it needs to be.
Madam Chair.
I will recognize the patron, and then we either operate by motion or we go to testimony. Your preference, if you'd like to have your testimony?
I would of course want to be respectful of their time and allow for
I think that would be helpful to make sure we have their perspective. Again, if you can limit your comment at first in the room. Is there anyone speaking in favor of HB 1219? Anyone wishing to speak in opposition? Online, we have the two individuals who I have recognized for information. First, Mr. Warner. Limit your minute to 2 minutes.
Madam Chair and delegates, thank you all for the opportunity to speak in support of Bill 1219. I just want to say that Virginia is one of the few, if not the only state in the country that doesn't allow for this, because they've had such a prescriptive requirement for search warrants, which can't be achieved for the purpose of these emergency responses. My name is Charles Warner. I'm a retired fire chief from Charlottesville, Virginia, and serve as the director of drone responders, a leading national nonprofit organization headquartered in Virginia. I work with and represent Virginia public safety agencies across all disciplines who are in support of this bill. This bill enhances safety of citizens, communities, and responders by providing real-time situational awareness over emergency scenes before ground units arrive. Nationwide, this fast response is a force multiplier by returning ground patrol vehicles to service to be available for other calls 25% of the time. For law enforcement, Chula Vista Police Chief Roxana Kennedy states that this has become the biggest de-escalation tool in their toolbox and has saved lives and prevented tragedies by seeing situations that help to de-escalate the response of law enforcement. There are numerous situations where this real-time situational awareness has provided critical information to de-escalate and reduce the response on numerous documented cases of saving lives in the United States. We work closely with counsel to ensure that this bill does not allow for random surveillance. It does not infringe on privacy and does not infringe on civil rights. So we hope that you can support this bill and appreciate anything that you need to do to move forward. Thank you.
Thank you. And now we have Jamie Pavol. Jamie?
Madam Chair and distinguished members of the committee, thank you for this opportunity to share with you the Prince William County Police Department's support of House Bill 1219. I would like to thank the House Delegate Brandis Wolf for sponsoring this bill, which would amend the current portion of the Code of Virginia governing the use of unmanned aircraft systems, commonly known as drones, and pave the way of reasonable and safe implementation of what is often referred to as drone as first responder or DFR. Police departments across the country are seeing substantial benefits in the use of drones as first responders. DFR has drastically shifted the way police departments are able to respond to emergency calls. And many jurisdictions, they have been utilized drone as first responders. They are able to rapidly and safely respond to many types of emergency calls in seconds rather than minutes. The responding drone provides police and critical perspectives of the scene, the circumstances, and even details on a potential suspect, which can be relayed to the responding officers. The benefits of this rapid response can certainly be measured, substantially reduce response times, but there are also massive benefits in the outcomes of swiftly closed cases, apprehended offenders, reduction in crime due to deterrence, and the increased safety and security of the community we serve. House Bill 1219 provides Virginia law enforcement agencies with the ability to implement DFR services and ensure that we will not fall behind the many other states that have already implemented these types of systems. Beyond DFR, House Bill 1219 also provides judicious approach that allows agencies to better leverage these particular tools that are quickly becoming rapidly available. Drones provide numerous agencies, not just police departments, with critical tools to quickly and comprehensively assess traffic, floods, infrastructure, and fire and rescue operations. As modern tools like drones continue to evolve and grow in acceptance, use of maintaining the safety and security of the community, we thank the committee for favorably considering the House Bill 1219, and I thank you for your time.
Thank you. Seeing no one else wishing to testify, Delegate Sewell, you have the final word on your bill.
Madam Chair, if Delegate Sewell is okay with this, I'm going to speak to it.
I have not recognized.
I'm sorry, Delegate Chair. I'm
Delegate
sorry,
Sewell.
Madam Chair.
Can hear me. Thank you, Chair Watts, for the chance to present this bill. Based upon the conversation that we have just had, it appears that most individuals on the subcommittee are comfortable with lines 373 through line 375, which allows for the establishment of a model policy for the operation of unmanned aircraft systems here in the Commonwealth, and they want to know what that policy will look like. So it sounds like the best way to move forward could potentially be to allow for that to and all other components of the legislation to be stricken from 376 on to ensure that we can narrow the scope of the usage of the drones and ensure many of the concerns that were noted may be addressed.
Okay, thank you for laying out that parameter as we consider. The next person I have recognized is Delegate Delaney.
Thank you, Madam Chair. So I'd like to make a motion. I think if just hearing what the patron said and kind of hearing the conversation in the committee, I think, you know, it's an important problem to solve. We're dealing with kind of some similar parallel discussions in the Transportation Committee as well, kind of getting, you know, not wanting to get ahead, but wanting to make progress. So would the patron find it to be a friendly amendment to have a delayed enactment clause that this bill would come back in 2027 session, delayed enactment clause, reenactment clause, to show that we're, you know, that we're serious about keeping this moving forward, and then retaining the language for the DCHS work group that would provide the model policy so that we could have the legislation back before us next session with the, and then ask that DCHS create the model policy by the end of the year.
That works. The current, oh, sorry, Madam Chair. Oh, it's to be recognized. I'm sorry.
I think that takes your one bracket a step further towards the middle. Do I hear a reenactment clause with a study?
Yes, reenactment. Got you.
So with that, is there a motion?
Madam Chair, that is my motion.
And I second it.
Okay. So it's been moved and seconded that we add a reenactment clause to the legislation before us, and that we also ask for DCJS, which is what you were talking about in terms of model policy. I'm going to say, as I'm hearing it, to study and report on the issue prior to the next General Assembly session, so that in the reenactment, we have the benefit of that report from DCJS. Okay. Yes.
Just to clarify, you're going to
Mr.
ask
Aubergere?
DCJS to propose a model policy when we report
And
back at the end of the year.
part of
That's
the
great.
report
That language.
of-
Okay,
Yeah. Mhm.
good.
So with that in concept as a reenactment, well, we both need a reenactment clause and also a clause for the report. Although, any further discussion? Clerk, please open the, let me see, we are reporting with reenactment, so please open the roll. Member, cast your vote. It reports with substitute, which will include the two additional reenactment and a clause for a report. Thank you very
Madam
much.
Chair and members of the subcommittee.
If I'm looking at my list correctly, now it is time for HB 1411, Delegate Schmidt.
Oh, okay. Okay, thank you, Madam Chair, members of the committee. I have Bill 1411. I want to start by thanking staff for working very diligently on this issue. I will give a little context, and I may have to rely on staff to, sorry. Well, let me move this. We have a substitute. Let me move the substitute.
Move the substitute.
Thank you.
All those in favor say aye.
Aye.
Opposed?
We're looking at the snow, and I'm like, okay, quickly. This is a little bit of a in the weeds as far as procedurally, but just to give a little bit of background, for years and probably forever, based on a 1985 case, Virginia had basically one way to bring in any sort of mental health or mental condition. That was, of course, pleading insanity or incompetency, and there was a direct way to do that, and it was separate and it had to be done at the beginning. Otherwise, you could not enter any evidence as to the mental state of a defendant to mitigate harm or mitigate the damages or talk about whether they could form the mens rea or, the idea, the criminal mind. And so for years, the Commonwealth studied this, and then in 2020 or maybe 2021, not sure, we basically introduced the concept of being allowed for defense to enter in evidence as to the mental health and mental state of the defendant for a whole host of reasons. Then, fast forward a few years, the law was in practice, and more recently, we've had some case law, particularly a case, Shaw versus Commonwealth, that unfortunately, in my opinion, and I think in the advocates that brought this to me, has gone outside the original intent, the original legislative intent of the law. And so we're trying to fix that. One of the main issues, I won't summarize Shaw because it's a lot, this is the homework behind it, but the main issue with Shaw was that the defense tried to enter in from expert testimony the defendant's mental health and past mental issues, diagnoses, and things like that. And because the judge ruled that because the expert could not come to a conclusion about whether that mental health issue impacted the ability for the defendant to form mens rea and form the criminal intent, that it was inadmissible. And that was never really the intent of the law. The intent of the law of introducing mental health, the mental health of the defendant, is just like any other evidence. The jury gets to weigh it, or the judge gets to weigh it. They get to figure out whether it's probative, whether it's prejudicial, what all the other rules around evidence and introducing evidence in a criminal trial. So that's what we're trying to do here. It's not a simple fix, but we're trying to get back to the original intent of the law that allows for defendants to bring in mental health as part of the evidence. And I can cite examples of when this is relevant and why this bill was, why this was originally passed into law in 2020 and 2020 or 2021. I can't remember exactly, but with that, I will stop, answer any questions, let staff correct me if I have misstated anything. But that's the bill, is trying to correct it to get back to the original legislative intent of the statute allowing for mental condition as admissible as evidence.
Are there any questions of the patron? Any questions of council or comments? If not, yes, Delegate Davis.
Thank you, Madam Chair. So, a question for the patron. This even allows lay witnesses to come. So, mom comes in and says, little Johnny has this. That's correct. Submitted to the jury.
Correct.
Or the judge.
Yeah, the original intent was to have to be able to allow witnesses to testify to what they know, and if anybody ever went to the realm of I know that my child has autism, I know that my child has mental disability, then traditionally that was not allowed because that would go into bleeding into that area that was prohibited. But yes, the idea is that the jury, the judge would be able to weigh the evidence and the testimony, and be able to say, thank you for your testimony, that's irrelevant to what we're doing, or that sort of thing. So
thank you.
But maybe a clarifying from the staff. Thank you.
Well, and just to clarify for Delegate Davis, the rules of evidence do allow for technically lay witness testimony as to insanity. That's already included in the rules of evidence. So this would kind of mirror that. But that's been part of the rules of evidence, that a lay witness can actually make that conclusion. I don't know if anyone's used it, but it is in the rule.
I would also ask counsel, as I look at the text, I'm at the end of line 18, it has little Romanet I, has any tendency to show the defendant did or did not have the intent. I'm sorry, forgive me, I dropped a line. I'm at the beginning of 18, is not evidence concerning an ultimate issue of fact. So it comes in, right, but it's not definitive about a particular fact. It is all to be weighed in the evidence presented.
I think that language was added because courts weren't allowing it in because they believed it went to the ultimate issue. And then the Shaw case said the evidence was not allowed because the expert could not conclude the ultimate issue. So I think the goal from the patron is to clarify when the court can consider this evidence, and ultimately the finder of fact would be the one to determine if the mental state had been proven or if the mental state was not proven because of the defendant's suffering from one of these mental illnesses in the statute.
Thank you. Seeing no one else wishing to speak, is there anyone in the audience who would like to testify in favor of 1411? And again, if you would limit your testimony just to this bill and 1 minute, please. We've heard, we understand the context of what you've been through. Thank you.
Thank you. My name is Dr. Elisa Osterweil, founder of Mothers Reform Child Injustices, and I will spare you my survivor story. But there's an increasing number of mothers who are being arrested and incarcerated, not because they intend to commit crimes, but HB 1411 would address this. And so what happens in a lot of these situations where women may, well, I say women, but it's predominantly women, may act in self-defense, experiencing some kind of acute trauma, or it's their trauma response, or it might come across as reactive abuse due to, a previous event that occurred, but the police didn't observe that. And so survivors who are experiencing this kind of coercive control, dissociation, or panic, they may give the appearance of, well, they are in a mental state that is, they're not mentally insane or mentally ill, it's just their trauma response to violence. So it's not, it doesn't arise to the level of mental insanity. They don't have a diagnosable mental condition. It's just it's situational, where that, their mental state, especially when it's something that involves their child, you get the mama bear, like mama elephant, where it's, that reactive abuse. So I think,
Thank
yes,
you.
please. Thank you.
For that clarification. And we also have online, we have two individuals, Brad Haywood from Justice Forward.
Thank you, Madam Chairwoman. Brad Haywood, Justice Forward, Virginia. I actually argued the Shaw case in the trial court, Court of Appeals, and the Supreme Court. And our organization was closely involved in drafting of this bill back in 2021. Most of the concerns most of the points that were raised today, like the ultimate issue, they're being applied appropriately, actually, and that is the current law. What has happened in courts over the past several years, most courts are applying this, well, I'd say the large majority are applying it the way the legislature intended, but there are a sufficient number that aren't, that, for example, are trying to interpret this as an affirmative defense rather than a rule of evidence, or are trying to establish burdens, like a weight of the evidence type standard before they allow the evidence in. The intention of the legislature was drawn from the Model Penal Code and the American Bar Association standards, and those have been around for over 50 years, and they've been implemented in other states. Other states know what they mean. There's tons of jurisprudence on them. We just have to close the loopholes, the ones that have arisen over the past several years, and that's what this bill does. Right down the line, and I could speak to any of these if necessary, but one, I guess I would just say right now is currently, under current law, lay witnesses can testify in support of this. So, thank you.
Our next speaker is Tom Jackson from Virginia Recovery Advocacy Project. And I don't see that he is online. That concludes the testimony.
You didn't take opposition.
I didn't take opposition. Thank you for reminding me. My apologies. Thank you. Please come forward if you are in opposition to HB 1411.
Madam Chair, members of the committee. I will say, Mackenzie Babachenko, Hanover County Commonwealth's attorney. I am here on behalf of the Virginia Association of Commonwealth's Attorneys. I will say that I do appreciate the substitute bill, which alleviated one of our major concerns, but there's still a bigger picture issue, I think, here. While we're really expanding diminished capacity, we're going from specific, the intents, having this type of evidence go to intent, and then just broadening it to mental state. That is an element. So that's just your general mental state, and kind of all evidence of mental condition is coming in. And I understand where the patron was coming from. We had an opportunity to discuss this, and I appreciate that. And I think we'll be able to, I would like to be a part of conversations moving forward on looking at this if Virginia is going to be a full-blown diminished capacity state. But the problem I see here is that we're trying to change this law, but we're not doing all of the other things that are going to be impacted by this law. Like, what is the jury going to think or see when they're going to hear this evidence, it's not like other evidence. It's very, very complicated. So it's, your robberies, your internet sex crimes, rape, stalking. There's not another reduction. So this is just a dismissal if they're confused or overwhelmed and don't know what to do. So dismissal, nobody's getting help, public safety concerns. So VACA today, like this, opposes the bill. Thank you.
Thank you. Having heard the testimony, then let me just turn to counsel before asking for the final words from the patient, from the patron.
The patient?
No, I think we've answered all questions unless someone has anything else.
All right.
Yeah.
Delegate Schmidt.
Thank you. I will say that I believe the Office of OES noted that this would have a fiscal impact. So it needs to go to appropriations, I believe, because of the possibility of indigent clients needing to access expert witness testimony and not being able to pay for it. So that would come out of a fund that don't know the impact of it. So
thank you.
Thank you.
Is there any other comments? We operate by motion, and again, it needs to be referred to appropriation if we report. Report, refer the substitute. Okay. Please, clerk, please open the roll. Members, cast your vote. And HB 1411 is reported by a vote of 7-3, reported and referred to appropriation with substitute. Thank you. And we also then have HB 637, Coulson. Thank you. Please proceed.
Thank you, Chair Watts. I have a substitute. If I could get that entered in, and then I'll speak about it.
Moved and seconded. Any questions? All those in favor say aye. Opposed? Great. Please proceed. The substitute is before us.
Okay, so for a bill that is actually about the smallest quantity of things, actually unmeasurable amounts, the substitute's pretty interesting because it takes it from like a 1-paragraph bill to an 18-page bill. But if you stick with me, I'm going to try to just cruise through, and I'm just going to start with the purpose of the bill, which you have seen it. Most of the people here have seen it in 2024. It's creating a misdemeanor for residue possession. Currently in Virginia, all possession is classified as a felony. And although this is in no way a VCJC bill this year, it started as a VCJC bill because they were finding that what was happening in a large majority of cases, prosecutors didn't have the discretion. They felt like the felony was too tough, and so they were using legal fictions to basically downgrade the charges. So they were either charging it as drug paraphernalia, which is not a true and accurate description of what was happening, or they were doing deferrals, or they just weren't charging it because they didn't want to do a felony when it was truly a residue amount, a non-usable amount of drug. So we carved out fentanyl during that year. It was vetoed. I am bringing it back. Now, how did it end up as an 18-page bill? That is because our intrepid and great DLS attorneys did a much more thorough review, and they tried to find all the places in the code that it might affect if we were to drop things down to misdemeanor. And so I am not, in the interest of time, I'm not going to go through that, but it is the majority of the bill. And if you have questions about any of them, it's like just making sure, like wherever we have provided an exemption for simple possession, we also include residue possession, so like hemp producers, medical marijuana licensors, the harm reduction programs. That's what the majority of it is. I am going to go to where the substantive changes are. And it is late, so bear with me if I miss some. So substantive changes, it is dropping everything down. So Schedule 1 and 2, simple possession of residue, instead of being a felony now, will be a Class 1 misdemeanor. And then every other schedule of drug below that will drop down 1 misdemeanor charge. Schedule 3, 4, 5, do we have any more after that? 5 and 6 are the same. All of those are already currently misdemeanors at pure possession. So as residue, they will remain misdemeanors, but they will drop down one misdemeanor charge. As a reminder, those are still punishable. Many of those misdemeanors are still punishable by big fines and by jail time. So still opportunity to seek treatment and effectively deal with it. I am not carving out when you have a gun and drug possession, even if it's residue. I'm keeping that the same, whether it's residue or simple possession. If you have a gun, we don't want to see that, so that's staying the same. And then, still carving out fentanyl, the first offender drug program. So I'm adding residue into that. We right now have a first offender drug program where we do not, if you have a prior misdemeanor marijuana charge, we still allow you to classify as a first offender and enter the drug program. And I'm saying that if you have a prior misdemeanor residue charge, you can still get the first offender drug program. So that's the bill in a nutshell. I am trying to move fast, happy to talk more if you guys want, but I'm going to stop there.
All right, Delegate Williams.
Yeah, Madam Chair, when Delegate Carlson first got here, I was speaking to Delegate Carlson. I got a question for her. I'm making sure I got recognized.
I said Delegate Williams.
Perfect. Thank you, Madam Chair. I rizzed her pretty hard on fentanyl, and I think you fixed that issue for me. And then the other thing was, I heard you talking about moving them down. I didn't understand what you were saying. What you're saying is, like, if there's a residue of like Schedule 3, you're going to move that down. So you're not actually, making Schedule 3s less dangerous or whatever. So thank you.
Yep. I'm sorry, I'm trying to go through it fast, and it is 18 pages, but you can always visit me and I'll tell you. That's correct. That is what I'm doing, Chair Watts.
Please. That concludes that questioning. Is there anyone else being recognized to speak? Seeing none, I believe then, Council, is there any concerns that you wish to bring to our attention? Is there anyone in the audience wishing to speak in favor of HB 637?
If I may, Chair Watts.
Is there anyone wishing to speak in opposition to HB 637?
We outlasted my proponents.
And again, please make sure that we're speaking to the residue issue of narcotics.
Yes. My name is Dr. Elise Osterweil. I'm a toxicologist with over 25 years of experience, molecular and environmental. Have conducted thousands of risk assessments, not illicit drugs, but I do have some concerns about how to define what a residue is, because defining it as an amount that is too small to be weighed accurately is not a really measurable or scientific definition of what a residue is. And I looked at the DCA, and they really don't have any definition of what a residue is, and it would vary depending on what illicit drug that you're talking about. And so this is really important because there's an increase, because these drugs are just so ubiquitous. There's a lot more background levels that are being found in air, water. If it's smoked, it's found in like your clothing and wherever, and in the air. And so innocent bystanders could potentially be charged with a residue. So I think it really needs to be defined, like what that actual amount is that's not measurable, because it also depends on the type of instrumentation that you're using, because there's no such thing as not measurable. I mean, we can go to the nanomole, so I think that needs to be more clearly defined.
Thank you. Seeing no one else wishing to speak at this moment, if I could please ask a question of your expertise.
Me or?
I was just wondering if there is any reference to measurable amount as determined by. Very often we have testing labs, et cetera, and whether there's a reference that we can make.
Chair Watts, if I may respond, we did go back and forth with measuring, and the first time through the bill, and where we landed was on the definition that is used by, and this is where I'm going to turn to our staff.
This is the standard that DFS, the Division of I don't even know what you call it, forensic sciences, is actually in their manual that they have. When you get a COA, certificate of analysis, back to the court, it would say it was to it was too small to be weighed accurately on the certificate of analysis. So it technically is like as residue. So that is our standard.
But they are, so you've just referred to forensic labs. So is there something that we can just put in here as defined by Virginia Defensive Forensic Lab?
No, because that is in the manual for DFS. So that's where we pulled the language from, speaking with those lab technicians and workers. I think that was 2 years ago. That was the conversation that was had, is just use this language from the manual that we have.
Let me try again. So there is a Virginia Forensic Lab which measures all kinds of evidence that is brought before them. So what I'm looking for, if they say that it's not measurable, that meets the definition of it not being measurable. Yes, Abby?
The labs that come back, they say residue, the certificates of analysis. So the lab will take it, and if they can't measure it, they can still test it, and that comes back cocaine residue. So it says it on the lab report, and the Commonwealth would need to introduce the lab report to convict someone. So it says the word residue on the lab report. So that's where the lab is getting that definition. They can't measure it when they go to test it. They can only test it.
Let me try again. Is it possible to say as found by the Virginia Forensic?
I don't know.
If the committee would like that language to be included in the bill, it can be added. Again, it's not a defined term like we technically would use, as this term is defined in 18.2-57, as this term is defined in 17.1-805. If that's what you want it to say, I can, but if we link it to the manual and the manual changes the definition, our definition would consistently be changing. This is the measurement that DFS uses right now in the manual.
Thank you for that clarification, but I'm still going after, this is why I'm tying it. This is a lot better to tie it to something that our laboratories in Virginia are using, rather than having someone who is in defending themselves say it was too little to be measured. You can't possibly do that, and perhaps it's more than. So I want to tie it to an authoritative decision of it's too little to be measured, and that's what our laboratories do when they declare it's residue.
Chair Watts, if I may, I can certainly, I remember 2 years ago us having these conversations and talking with people. I am committed. I can start reaching out. We can try to find them this weekend and see if there's a way that they're, the way that we can refer to them or figure out exactly what's going on outside of this committee meeting right now, because my understanding is actually there's a test result you get, so maybe we can say, like, if you get that, as verified in a test result or something like that, we can consider adding. I'm happy to do that. And I'm also happy to go by to Monday if you need.
We're only halfway through, and I trust that this is an issue that if it can be addressed, there'll be more definitive attachment to residue. Thank you. I have no one online, I believe. 6:37. I do. I have two individuals online. Again, Brad Haywood from Justice Forward Virginia.
Thank you. Just so the committee knows, this actually, the issue we're trying to deal with here is a product of the war on drugs itself and the Drug Control Act from 1971. Prior to then, the law used to require a usable quantity, not a detectable quantity. And obviously residue isn't usable, can't be weighed, can't be used, can't cause feelings of intoxication. It's dangerous to no one. What it is, it's proof that someone used drugs at some point in the past. It's akin to a witness coming up to a cop and saying, I saw Mr. Smith use drugs yesterday. Something like that shouldn't be a crime at all. That's a public health issue. It definitely should not be punished with felony convictions and up to 10 years in prison. We would ask the committee to report the bill.
Thank you. And I do not see the other individual who has signed up. Therefore, you have the final word on your bill before we turn to the committee.
Well, I just have a few pages to read about that. No, I will end with saying this is actually just about fairness and truth in our legal system. That's how the bill originally came to me. Right now, they are already downgrading simple possession. This is not possession, this is not drug distribution, it's not any of those things. They're already downgrading it to misdemeanors. They're just doing it in really squirrely ways that convolute the process and make it so we don't have an accurate record. So that's what I'm trying to stop.
Thank you. Delegate Delaney?
Thank you, Madam Chair. So I appreciate the patrons' willingness to work on, between now and potentially the full committee, on ensuring that the references are all very science-based and consistent. So with that, I do make a motion to report the bill as amended? It's a substitute report, of course.
And is it a report and refer? No. No. Okay, a clean report of substitute. Any discussion? Clerk, please open the roll. Members, cast your vote. Okay, HB 637 is reported with substitute by a vote of 8-2. And as I see the papers before me, that is the last bill on our docket. You all.
One more.
Oh.
862.
I'm welcome. I knew another vote. Excuse me. Another bill on the vote. Delegate, just get the right one in front of me here. Delegate Coulson.
Cousins.
Yeah, just where is?
Thank you, Madam Chair. It's 862.
Which bill do you have?
862.
Thank you. 862. 862. Would you like to present at the podium or?
If I can present from here.
Okay.
Thank you, Madam Chair. So I do have amendments to report.
Move the amendments.
Second.
Thank you. And if I could just have council report these, that'd be great.
Yes, Madam Chair, Delegate Coulson, members of the committee. These line amendments, there are 2 line amendments. The first one strikes a drafting error and replaces the word fiscal with finance on line 955. The defined term in the bill was Executive Finance Committee. Then with extra changes on line 1147, after January 1st, we're going to strike 2027 and insert 2028. Then after line 147 as introduced, we would be adding 2 new enactment clauses. The 7th one would state that the provisions of 18.2-273.6 of the Code of Virginia as created by this act shall become effective July 1, 2027. So that specific code section in this bill would not become effective until July 1, 2027. And then the 8th enactment clause, which I am not going to read in its entirety, but it is a work group that the Secretary of Health and Human Resources, in consultation with the Secretary of Public Safety and Homeland Security and the Secretary of Transportation, will get together to review the sustainability of the structure and funding model for the VASAP program with delineated things to research and report back on by October the 1st, 2026. To the governor, chairs of House Committee on Appropriations and Senate Committee on Finance and Appropriation.
Any questions on the report? So the bill as amended is before us. Would you like to speak to it?
Yes, thank you, Madam Chair. HB 862 is a recommendation of the Virginia Alcohol Safety Action Program Commission, or the VASAP Commission. The majority of this bill is organizational in nature. It consolidates the commission's statutory authority into a single section of the code for clarity and consistency. It also requires each local ASAP to have a fiscal agent derived from one of the municipalities it serves, clearly defines the responsibilities of local policy boards, and establishes a requirement for local municipal funding when a program is in financial distress. At present, individuals convicted of the same offense may receive different levels of service or support based solely on where they live, and so this bill seeks to address that issue. The goal of this legislation is to standardize the structural framework across the Commonwealth and to strengthen local participation in programs that are locally established, and also to serve local stakeholders. And there are some representatives from VASAP here today to speak about the bill.
Thank you, Delegate Cousins. If those representatives would come forward, if you would provide testimony, and then if there's anything to be clarified, the members can ask questions after your testimony. 2 minutes.
Good afternoon, Madam Chair, members of the committee. Christopher Morris with Commission staff. We want to thank Delegate Cousins for carrying this bill. It was developed by a Commission subcommittee and unanimously approved by the Commission. The majority of this bill, as Delegate Cousins says, consolidates existing ASAP code and regulatory authority into one section. The rest addresses the root cause of program failures at the local level, and that's sort of what I want to focus on. The state office has had to go into multiple programs multiple times over the past 10 years, and we've had to rebuild these programs from the ground up. There are some programs that have a fiscal agent and they have municipality funding, and there are some that do not. It's not an error or a coincidence that every one of these programs we went into to rebuild did not have that. And we are trying to address the root cause of that in this bill. And when we go into those programs, this is what we find. We find clients who haven't been serviced in months. We find compliant clients who have not been set free. And we find non-compliant clients who have been let go. We find limited staff that was overworked and underpaid, and we find critical bills that have not been paid by the administration there. Right now, 2 defendants with the same conviction can receive very different levels of supervision based solely on where they live. Equal justice requires equal access to the systems that enforce them. We did put things in the bill that to help the municipalities. They can collect up to a 10% fee from the annual budget of the ASAP. And also the money that they spend out on behalf of the ASAP is derived from offender fees from the ASAP. They send that to the municipality in advance, to the local municipality in advance. What this bill does, it's not waiting for data, it's acting on it. It's not shifting responsibility, it's defining it. And it's not creating barriers to compliance, it's removing them. So we humbly ask for your support.
Thank you. Is there anybody else wishing to speak in favor of HB 862? If you all could split 3 minutes.
Good evening, Madam Chair and members of the committee. Thank you for the opportunity to speak. My name is Alicia Klein, and I'm the director for the Rappahannock Area ASAP. I support this bill because it establishes accountability and consistency across all alcohol safety action programs, performing court-mandated functions throughout the Commonwealth. It provides the Commission with clear authority to address programs that are not meeting required standards, while creating a more uniform framework for how ASAPs operates statewide. For those reasons, I support the bill and appreciate your consideration. Thank you.
Madam Chair, members of the committee, my name is Ashley Cole, and I am the director of the John Tyler Alcohol Safety Action Program. We are the largest program in the Commonwealth, serving 20 jurisdictions, including Chesterfield, Henrico, and Richmond. And of the 20 localities that we give services to, we receive funding from 0. As a member of the Commission on BASAP, I voted for this bill, and I wholeheartedly support it. Thank you.
Good evening, Madam Chair and the committee. My name is Jen McVeigh, Director of Old Dominion ASAP. Our program covers the jurisdictions of Clark, Frederick, Page, Shenandoah, Warren, and the city of Winchester. We have the benefit of an all-encompassing fiscal agent in Frederick County who provides services in kind at no cost to our program. In addition, we also receive financial support from our localities. Without local support, our agency would not be able to maintain the quality of the mandated services that we provide our constituents. If an ASAP does not exist due to the lack of funding, those localities would bear the expense of providing programming to their constituents, which is far greater a cost in total when compared to the percentage needed to aid in the existing ASAPs. With that said, I support this bill. Thank you.
Thank you, and thank you for your patience in waiting to testify. Is there anyone here speaking in opposition to 862? If you could limit it to 2 minutes, please.
Absolutely. Good evening, Madam Chair and members of the subcommittee. And I think our position is a bit nuanced, and we've had a lot of conversation about this bill, and I appreciate that. So very much appreciate the discussion on this bill with the patron and the commission staff. So, we understand this legislation was the product of an internal working group at the BASAP Commission. Local governments were not part of that conversation. So we really appreciated being able to meet with commission staff and kind of understanding where this bill is coming from and the aims of the bill. And much of this is unobjectionable to us, the organizational things, the structural things that were being discussed. So as introduced, we've been concerned mainly with the big 2 policy issues here, or provisions requiring the localities to provide that financial contributions and then requiring localities to serve as fiscal agents. And so I think I understand that the version before you is delaying that fiscal agent effectiveness, and we had proposed a working group language, which I think has also been included. I think the fundamental issue that has been bedeviling this program for so long is that it's intended to be funded by fees, and those fees have not been increased since 1986. Often they're waived by judges, and so the finances have been strained all along. And so we think it is worth a broader conversation about how this program should be supported. Maybe it's time for some state general fund support, or maybe some other type of non-general fund appropriation that can support it. So I think the provisions that sort of presume that this should be a local funding responsibility, we would like to talk some more about that. So if this bill should move forward, we would welcome the opportunity to kind of continue to have that conversation with the legislature. So thank you. I'm sorry. Oh, I'm so sorry. I'm Katie Boyle with the Virginia Association of Counties. I haven't made that mistake all session, so I've done it now. Thank you all so much.
Madam Chair.
Thank you.
Can I ask a question?
And again, this was on behalf of the VACO or also Municipal League?
We have been working together with the Municipal League. I don't have their explicit permission to speak, but we have been working together.
Yes,
Chair.
Chairman Hope.
Can I ask Ms. Boyle a question? Do you know how many localities contribute something to this program? Or maybe better question is how many do not?
I was getting some information from Mr. Morris in the hallway, and I think, did you tell me that 19% contribute approximately? And I think some of it is financial and some of it could be in kind, like renting a building or perhaps serving as a fiscal agent.
Okay.
So I think there is a spreadsheet that Mr. Morris might have with some more detail. We have been trying to gather some of this information ourselves.
Thank you, Ms. Boyle. Can I also ask Mr. Morris to respond to Ms. Boyle? Because some of the things about the fees, I'm the vice chair of the VASAP, and so it wasn't very clear to me. I don't know if you had anything that you wanted to
If you could please come forward.
Respond.
Madam Chair, members of the committee, we had several bills that came out a couple years ago to raise the ASAP fee. They didn't go anywhere because we didn't want unaffordability to be a roadblock to compliance and highway safety. When we go into these programs, we are working with clients that are barely making it. They just had a conviction, so they're paying defense fees, they're paying court fees, their insurance is going up, and then they have an ASAP fee. The other thing is, we've talked to several municipalities and what we hear from some of them, and there are some that give a great amount of money to their programs. Fairfax and Arlington give a tremendous amount to their program. They serve as a fiscal agent, and those employees at ASAP are actual employees of the county. Southwest Virginia operates similar with Russell County. They have a fiscal agent, and we have several others that actually have a fiscal agent, but they may not get municipality support. But what we hear when we talk to the jurisdictions is that ASAP is state mandated, so it should be state funded. But it is actually, those programs are established locally, and they serve local stakeholders. So when we go into these programs and we go to the courts and we're rebuilding these programs, we're talking to a lot of judges and stakeholders, and the judges will ask us, well, can we get another employee? And we said, we can't. And they say, well, are you getting any funding? And we tell them no, and they're shocked. So it's widespread, but I can tell you this with 100% certainty. The programs that have fiscal agents as municipalities and have support from the municipalities have a pattern of success, and we have yet to have to go into one of them. What we're seeing, the damage and the carnage when we go into these other programs where clients they're basically giving up because they haven't had anybody listen to them for months. And that's what we are trying to really fix quick, because we've gone from 24 programs to 21 in the past 2 years. And my fear is coming back to you next year and saying we went from 24 to 18, because that's probably what's going to happen.
Thank you. Any follow-up, Mr. Chairman?
I'm glad to speak to the bill at the appropriate time, Madam Chair.
I also have Delegate Davis.
Thank you, Madam Chair. I have a question for legal. Are these VASAP fees some of the same fees that prior legislation that's been before us are allowed to be eliminated?
Yes, my understanding is a judge can waive the VASAP fees if the defendant makes a motion and it's usually based on indigency.
Follow-up question.
Yeah, please.
But the prior legislation that's coming before us in the prior days and weeks that allows the court to suspend or waive any fines and court costs, is the VASAP fee part of that?
I don't think the base app fee was included in that. No.
Thank you.
It would be a court's discretion.
Thank you.
Yes. Sorry, I didn't understand your question at first.
And excuse me, Delegate Hope? Yes.
I'm not going to repeat what's been said.
Sorry, Chairman.
No, it's your fine. I'm not going to repeat what has been said. I mean, we've got to express upon our localities that this is a worthwhile program to fund, and it shouldn't matter which jurisdiction I'm driving in to make sure our roads are safe. And I think that's a message that we want the localities here too. I think you heard Mr. Morris's testimony about those VSAPs that are most successful are the ones that there's this partnership. And I just think the state has got to start leaning on some of these localities to make sure that this continues to be a successful program. This VSAP saves lives. The interlock saves lives. I think the judges are frustrated. I think the local jurisdictions are frustrated as well too. And this is really just about standardizing our VSAPs across the Commonwealth. And we're gold standard, I think, when you talk to other VSAPs across the ASAPs across the country. And we want to maintain our position there. So I hope that we will move to support this bill, and I would make that motion, Madam Chair.
It has been moved and seconded.
Or substitute.
Any further discussion? Hearing none, it has been moved and seconded that HB 862 be reported as substitute. Pardon? Did we also have an amendment on the substitute? Okay, the substitute as amended be reported. Clerk, please open the roll. Members, cast your vote. I think we've done it. Excuse me, let me announce that HB 862 reports with amendments 10-0. And I believe that concludes the business before us. You've done yeoman's work. Thank you.